Unit 4 is really an extension of agency because it deals with a lot of the laws around trying to get clients. That's really what this whole unit focuses on. It's like, these are the laws that we have to follow when we're out trying to get people to hire us. So this section, this unit is all about how we look for clients. How do we engage with people in a legal way? Because there are quite a few laws that actually govern or dictate how we are allowed to reach out. And that's called solicitation, by the way. Solicitation is the process of looking for clients, of going out and trying to market yourself so that people are willing to hire you. That's ultimately what solicitation is. So when we are soliciting as real estate brokers, examples of that would be like calling people. And calling them for the purposes of, hey, are you interested in hearing what your house might be worth? That's a solicitation. Knocking on somebody's door and talking to them about potentially selling their house. That's a solicitation. Handing out business cards to potential buyers is a solicitation. Even folks, even posting on your own Facebook page or your own Instagram page or your own Snapchat. Hey, how many of you see real estate agents every single day that are like making videos of themselves going up to some showing, some open house and putting it on their social media?
Yes. Me.
That's a form of solicitation. And since that's all considered solicitation, we have to be really careful to make sure that we are following the various laws that come into play when we are doing those things, when we are out looking for clients. Is everybody okay on what when we talk about solicitation, when we say soliciting, what we mean here?
Yeah, it's fairly straightforward. This chapter isn't as long as I thought it was going to be either.
And by the way, I do want to point out, this is one of those things that an unlicensed assistant who works for a real estate agent in North Carolina, if they work for a real estate firm, if they work for a real estate broker, what's one of the things that the unlicensed person cannot do? What's one of the services they cannot perform for their employer, the real estate agent that they work for?
They can't hold an open house.
Marketing?
They can't, well, they can do marketing as long as they don't create the material.
I think it's staring at us.
Show properties for sale. They can show properties that are for rent. But I'm talking about the one that's staring you right in the face.
Soliciting.
What is
Can't
it?
solicit.
They can't solicit for business, folks. So here's a practical question. Can an unlicensed assistant who works for a real estate broker keep business cards for their boss in their pocket to hand out in case they hear somebody talking about wanting to buy or sell houses? No, because that is an example of solicitation, and that's not allowed under license law. So that's what I mean. You got to start to, connect those words back. When we say that an unlicensed assistant who works for a real estate agent cannot solicit, this is what we mean. They're not allowed to reach out to people and say, don't you want to talk about selling your house? Don't you, are you interested in us helping you find a property? That has to be done by the licensee themselves. Everybody okay with that? Now, I did hear somebody say marketing. An unlicensed person can do marketing as long as they don't create the marketing materials. If they are given the materials, if they're given the information. So like as an example, could I have an unlicensed assistant create a flyer for my new listing if I gave them all the verbiage, all the words that I wanted on the flyer? Could I have them lay it out and do the graphics and make it look pretty?
Yeah.
They're
Yes.
just doing clerical.
Yes, because that is more of a clerical function. That's more of an administrative function than it is anything relating to brokerage. Okay, but solicitation is one of those no-nos for people that don't have a license. One of, if not the single biggest area of solicitation where you're likely to see test questions has to do with the telephone. the National Do Not Call Registry. Telephone calls are very highly regulated. Now, this is one of those things where you cannot apply what you see in the real world. You have to learn the material and you're going to be tested on the law. I'm just going to be bluntly honest. Is this a law that is well enforced? Absolutely not.
No.
Most of us get and receive way too many garbage phone calls. That does not mean the law does not exist. And whether you think the law is garbage or not, doesn't matter. You're going to be tested on it. So we want to make sure you get the test questions right about the law. I also want to make sure you understand the law so that you don't violate it. Hopefully you're not adding to the problem once you're a licensed real estate broker. But anytime you're using the call, and by the way, let me point this out. Notice it's called the do not call or what?
Text or text.
So the same rules that apply to phone calls also apply to texting. People can place themselves on a list called the do not call registry. And it's at donotcall.gov. You don't need another website, but I just gave it to you anyway. Okay. Once they are on the list, they are not to be called or solicited or texted unless they ask for the phone call. Now and this is going to be where the test is going to really challenge you here. Can somebody who's on the do not call registry be called for a solicitation? Can I call somebody who's on the do not call registry and try to get their business? Can I?
No.
Yes.
If it's for sale by owner?
If they what?
I might get permission.
Unless invited. You're not going to be tested on, don't call them, don't call them, don't call them. That's going to be one of the answer choices, and it's going to be wrong. You're going to be tested on, what does it mean to be invited to call? Does that make sense for everybody?
Yeah.
Okay. So there's going to be exceptions. Now, let me be clear. If someone is not on the do not call registry, can they be called as many times as you want to for any reason you want to if they have not placed themselves on the list?
Yes.
Yes.
Yes, that is a yes. Okay. If they have not placed themselves on the do not call registry, then there is no restriction on calling them. But if they have placed themselves on the list, there are 3 exceptions to calling someone who's on the list and still not being in violation of the law. Okay. 3 main exceptions here. These are people who have placed themselves on the list and it is still okay to call them. And the reason is they invited the call. The idea here is if they invite us to call, we can. It would not be fair to hold a real estate broker responsible and fine the real estate broker $10,000 because they called somebody who's on the do not call registry if they were simply calling them after they had been asked to call. Does that, I think that sounds pretty fair, don't y'all?
Yep. Yes.
Okay. So let's talk about, and these are going to show up on the test, I'm almost certain, in the test question. The 3 instances where it is okay to call somebody who's on the do not call registry. Number 1, a FSBO can be contacted. A FSBO seller, for sale by owner, seller, can be contacted, even if they're on the do not call registry. Because think about it. What are they trying to do, folks?
They're
Invite people
trying to get somebody to call them.
They're trying to get somebody to buy their house, correct?
Yeah.
But let me be clear, because this is going to show up on the test and they're going to try to get you here. It's not the same thing to call that FSBO and say, hey, I'm calling because I have a buyer interested in your property. That call's okay. Here's the call that's not okay. Hey, this is Travis with Trav Talks. Listen, I had a buyer that's interested in your property. Would I be able to show it to them? So far, I'm okay. Oh, well, good. And by the way, while I'm there, would you like to talk about how we could list your property for you and maybe get you some more money for it? Right there. Have I switched from calling for the purpose of bringing them a buyer to calling to solicit them? Have I changed gears?
Yes.
Yeah.
Yes.
Yes.
And that last part is not allowed, folks. That last part is not allowed. So on the test, be very careful. Saying that you can contact someone who has put themselves on the do not call registry just because they're a FSBO, you better be willing to say, and the only thing we talked about is the fact that I had a buyer for their property. How we all feel about that? Okay.
When I first got into the business, I actually didn't check the do not call registry, and I was calling FSBOs like every day.
Yeah, and so you got to check. Now, if you're calling them to solicit listings, if you were calling them to say you had buyers, you don't have to check because that's the exception. If you're calling them to say, I have a buyer who specifically wants to, but my guess is that's not why you were
But
calling.
I didn't. I
Right.
did not have a buyer.
Right, you were calling them because you were trying to get a listing, right?
Yes.
And you learn. And luckily you didn't get the $10,000 fine to remind you about it. At least I hope not anyway.
No.
Okay?
Thank God.
The second one, so that's the first exception to the rule. The second one is a consumer who gives their contact information on a sign-up form. So if they fill out some kind of a form, that could be an electronic form on our website. That could be a paper form, like they come to an open house and we have a sign-in sheet. If we have a sign-in sheet in an open house and we put it there on the table and it says name and phone number and email address, if they give us their phone number, have they given us permission to call them?
Yes.
Yes.
Yes. Keep that in mind, folks. Anytime you fill out your phone number on a form,
Mhm.
now you understand you are legally giving permission for those people to do what?
All contact.
Call you. The theory here is if you didn't want them to call, you would not have given your phone number.
Right.
Okay. But that permission is for a limited amount of time. Take a look right there. How long is that permission good for from the time this person fills out that form?
3 months.
3 months,
90 days.
90 days. That's it. So essentially, if you host an open house and you keep a sign-in sheet, the next week you're free to call anybody on that sign-in sheet. You don't even need to bother to check the do not call registry, because if they put their name and phone number down, you're okay to call them on the list or not. Everybody, does that make sense for everybody?
Mm-hmm.
45 days after you did the open house, can you go back and call everybody that went to the open house legally?
Yes.
6 months later, you're going back through and you think, I'm going to call all these people that came to this open house because I have another listing in the neighborhood. 6 months later, can you call everybody on that sheet?
No.
No, at that point, you'd have to check the do not call registry and only call the ones who were not on the do not call registry, because anybody who was on the list, you no longer have permission to call them. Everybody okay?
Mm-hmm.
Okay. And so that's the second exception. The last one is your clients, people you actually had a business relationship with, people that actually hired you and your firm to represent them. Basically, from the end of your transaction, you get an 18-month follow-up period, year and a half to follow up. So theoretically speaking, and I'm just going to throw this out there, theoretically speaking, is it off limits potentially for me to contact some of my former buyers if it's been more than 18 months since I represented them in the purchase of their home?
Yes.
Yeah. If it's been more than 18 months, folks, I can't contact them unless they do what first?
Contact you.
Reach out to you.
Contact me. They got to contact me. They got to get in touch.
Bring
with
it
me.
back to, this is a solicitation rule. So if they're not on the list, then that rule wouldn't apply.
That's
You could
right.
still
So here's
contact
what it
them.
basically means. If I want to reach out to somebody and reestablish contact, even if they were my former client and it's been more than 18 months, before I reestablish contact, what list do I have to go check?
Do not call.
Do not
Do
Do
not
not
call.
call. But somebody that I sold a house to, I don't know, last December, do I even need to bother to check the list?
No.
No.
No, because I know even if they're on the list, I'm within the exception. Is everybody good on those 3 exceptions?
Mhm.
Okay, those are the 3 exceptions to the do not call registry. Okay, and so I put this one on here specifically. We mentioned it, but I put it in your notes so you won't forget it when you look back. One of the ones they love to trip you up with on the test, because they know when you're studying, you're looking for just like bullet points, key points.
Yes.
And one of the ones they will absolutely get you with a trap on the test is the FSBO one, because it is true that you can contact a FSBO, but only if you have who for their property.
Buyer.
Full
A
interested buyer.
client that is interested in their property, and you are calling to say, hey, can I bring my buyer to take a look at your property? In other words, you're not reaching out to that seller for a listing. You're reaching out on behalf of your buyer. You've been asked by your client, the buyer, can you get in contact with this FSBO? So be very careful with that one, because they love to throw that in there on the test. Changing communication type here. Move away from the phone, move away from texting. And remember, all those same rules apply to texting, not just phone calls, but texting. I can't text a former client if it's been more than 18 months since I represented them before I check to see if they're on the registry. Okay. Just as an example, apply the same rule. When you are emailing, there is a different law called the Can-Spam Act. The Can-Spam Act. Spam is unsolicited email marketing. And the Can-Spam Act is very simple, much less to know about the Can-Spam Act than about the do not call, do not text registry. Okay. The Can-Spam Act says one very simple thing. If you're going to send out marketing type emails, if you're going to send out solicitation type emails, they must include one very important link on them. What is the one link that a marketing or solicitation email must include in order to be in compliance with the Can-Spam Act?
Subscribe.
An unsubscribe link. Remove me from your list, unsubscribe me, take me off your list, link, right? Some way for that person to remove themselves from the mailing list so that you will not mail them in the future. In other words, it's not a violation to send them an email the first time. It would only be a violation if you did one of two things. Number one, don't include an unsubscribe link, or number two, continue to send them emails after they have unsubscribed.
I am all too familiar with this, with marketing for the school.
Exactly. When you send out marketing, and it is a big deal, right? When you start to get in this business and you start to do marketing, if you have too many people unsubscribe from your emails, if your email service will shut you down because they have to stay in compliance with this law. Or too many people complain that you're not unsubscribing them. All right, how do we feel about that? Everybody okay? Can-Spam Act. So far, what types of communications have we covered and the regulations around them?
Text, phone,
Text,
email.
Email.
Phone, text, email so far.
And fax.
Now we're about to talk about fax. Now, some of you have no idea what this machine is.
I never see it.
I hope I never see another one. To be bluntly honest, they do still use them in medicine. I understand. I think pharmacy. It's very hard to hack into a fax machine. So I know pharmacies use them when prescriptions cannot be sent electronically. They have the fax machine as a fallback, and it still exists. For those of you who are chronologically challenged and have not accumulated many years in your life yet, this was email before email existed. Basically, imagine a photocopier that connected to your phone line and sent a picture of the piece of paper and talked to another photocopier on the other end that printed out the picture of the piece of paper. Except you could almost never read anything that they actually submitted because it always had 40,000 lines everywhere. It was the worst, most god-awful technology you've ever seen in your life. But fax machines do apparently still exist, and you should know that they are regulated. I cannot imagine you will ever in your entire real estate career be soliciting people by fax. If you are trying to get clients by fax machine,
Different.
I
Think
don't
outside
know.
the box.
I don't know what age group you're targeting, but my guess is it would be an old one. Just FYI.
What are you talking about?
The fax machine is definitely old.
So we'd be targeting you?
Older than me, and that's old.
I'm kidding. I'm kidding.
Way older than me, and that's old. I will tell you this though, when I first got in the business, we did a lot with fax. Just as a fun side note, we did a lot with fax machines when I first got in the business. And some people, even though it was already outdated technology by that point in time, were using thermal fax machines. Now, to give you an idea what a thermal fax machine is, you know, the receipt paper that you get at the grocery store or Walmart, the slick, the really slick paper, and it's not actually printed with ink, it's printed with heat, right? Well, fax paper was the same way. Number one, it was the most ridiculous thing because the paper was not in sheets, it was on rolls. So the fax came off and you looked like you were Moses coming down off the side of the mountain because you had this big scroll that you had to unscroll because the paper was all rolled up. That's number one. Number two, don't forget and leave the fax of the offer you just got in your car over lunch. Because when it got hot in the car, guess what the fax paper would do?
Turn black.
It would turn completely black. You couldn't get a damn thing of what somebody had faxed you on there because it was heat responsive paper and the whole thing would turn black. Just FYI. Yeah, exactly. It was an interesting time to be alive, for sure.
Maybe I should stop answering these questions because it's showing my age.
It is. It is. One of the most important, and it does say in North Carolina, I should put the state flag on here. I need to go back and add that because obviously this is a North Carolina specific slide right here. In North Carolina, any solicitations we do, and we're going to mention this again this afternoon when we talk about in 1.3, but it's worth mentioning here as well. We are not allowed to place what we call blind ads as a real estate broker. Let me try to explain why they call them blind ads, and then I think you'll understand why the rule is what it is. A blind ad is one that you cannot tell was placed by a real estate licensee. If you can't look at the ad and say, oh, that's their real estate agent that I'm contacting. If you can't look at the ad and say, I know that I'm not contacting the seller, I'm contacting their real estate agent, then the North Carolina Real Estate Commission considers it a blind ad. Does that make sense for everybody? Because we want consumers to know the difference between calling a seller and calling a broker who's representing a seller. We want consumers to know that they're reaching out to somebody who's a real estate agent, a licensed professional, versus somebody who's just calling a seller. And the only way we can ensure that they know that is make sure that the ad gives that information. So in other words, a blind ad would be an ad that does not give enough information to be able to figure out that the ad was placed by a real estate broker. And here is what the North Carolina Real Estate Commission says would make an ad blind. If you don't have one of two things, doesn't have to be both. Hear me. One of the following two things must be on any ad placed by a real estate agent. Number one, and this is the one by far most commonly used, the name of the firm placing the ad. So the name of the real estate firm that is placing the ad. Or, this is the second option, the name of the broker in charge who is placing the ad. Now, did I say the name of the individual licensee, the individual broker?
No.
No.
No. Did I say you can't put the name of the individual licensee or broker?
No.
No. Can you put the name? Can Seth put his name on his real estate signs?
Yep.
Yes.
Of course he can.
Because
As long as,
Technically could put anything.
as long as he also includes one of two things. What one of two things would be possible for Seth to put on his signs when he places a property on the market?
The
Name
or Trav Talks.
Either Travis Everette, broker in charge, or
Trav Talks.
Trav Talks Real Estate, Ellis.
I don't think I've ever seen that on an ad. Where do you usually put that?
the
They
firm
usually,
name.
they usually use the firm name. They don't usually use the BIC's name.
Correct. Almost nobody uses the big name. And that's why I said it's an either or. It's not both. And it makes sense. Why are you going to put your BIC's name up there when you can just put your office name? So
And
most-
also mine is really, really tiny in the corner. It's on
Exactly.
the ad.
Because, he's all like, protective and guarded, and he wants to advertise Seth for whatever crazy reason.
Mhm.
And
So
so,
my name's big.
he's got this whole like Seth Thomas real estate signage. He doesn't use the same logo. That's all fine as long as somewhere on that sign it has what? Either what?
Travis Everett
Travis
Big or
Everett
Travis
Trav Talks
Everett, broker
LLC.
in
That's
charge,
okay.
or
Trav Talks
Trav
LLC.
Talks LLC.
Trav Talks LLC. He has the choice, one of the two of them. And so here's what his signs say and his business cards say: a broker affiliate of Trav Talks LLC. Does that meet the rule?
Yes.
Yes.
And it's so funny because literally like I have it where you can see it, but I like to make fun of the rule because even though this is not how it is, I always like to say, and it's just one shade lighter than the other one.
Look, this is the perfect example of how the real estate commission is always regulating from behind. So we never had this rule. And then there was a big outcry where people were like, we can't tell who these people work for, because people always used to put the name of their office on their signs and on their business cards because you wanted to be identified with your office. Your office was a big deal. And then we went through this whole like personal branding phase in the business, and nobody put the name of their office on their cards, on their signs. You couldn't tell who anybody worked for because here's why. People were changing offices left and right. And if they didn't put the name of their office on their cards, if they didn't put the name of their office on their sign, if they had their logo, if they had their sign, could they jump from office to office and never even have to update signs and business cards?
Oh, yeah.
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 And so they weren't like identified with their office, and people went through this whole phase. But then there was a ton of complaints of like, well, I'm complaining against this person, but I don't even know what company they work for. So I don't know what broker in charge we're supposed to be sending the complaint to. You see how that's an issue for the real estate commission?
Mm-hmm.
Yes.
So they came back and they changed this rule, and they said, okay, you got to put your firm name or your broker in charge name on your signage. Guess what? Everybody did who had signs that didn't have their firm name or BIC on it.
Put
Put a sticker on it.
That's right. They went out and got a little tiny sticker from Staples, like the size of a postage stamp, that said a broker affiliate of Remax Winning Edge, and put it on the corner of the sign, because the rule didn't say it had to be big enough that you could see it. It just said it has to be there. And so the rule has not been very effective, but it is the rule. Now, how's that going to show up on a test? Look at this right here. It says, beautiful 3-bedroom, 2.5-bath home in Renaissance Park available for you today. Great open floor plan with 1,850 square feet, hardwood floors, gleaming granite counters, and amenities you won't believe. Call Seth Thomas at 919-999-5555 or email sethsellsrdu@gmail.com to schedule a showing or get more information. Full listing available at www.rockingrenaissance.com. That's one ad. Or 3-bedroom, 2.5-bath available. Call Seth of Trav Talks Real Estate today to schedule an appointment. Which one is allowable by the North Carolina Real Estate Commission and which one is not allowable?
The
Number
second.
two.
But it's number one, allowable number two.
This one's okay. This one is a no-go. Even though most people would look at the first one and say, well, that's the better ad. It gives far more detail. Because here's the thing, in the second one, they don't even know how to get in touch with Seth, do they?
Mm-mm.
Right.
Right?
No.
But it meets the rule. Because what is identified in the second one?
It's agency.
Firm.
His firm name. In the first one, I do not know what firm he works for, and I do not know his broker in charge's name. If I don't know either one of those, the ad doesn't work. Does that make sense for everybody?
Yep.
So I do have a question in my private chat that says, so how would the rule apply to someone like Travis if they might be a broker in charge? Do they just put the firm name?
Well, no. I can put either the firm name or the name of my broker in charge. Is Travis Everett the name of my broker in charge?
Yes.
If I put Travis Everett on my signs, am I in compliance with the rule?
Yes.
Yes.
Yes. So it's real convenient for those of us that are bigs.
But you don't have to identify yourself as the BIC.
No, just as long as the name's there. Just as long as the name is there.
So I could put my BIC's name, small print, 2 font at the bottom right-hand corner of my BIC
That's it.
and not even give their title.
That is correct. And that would be in
Okay.
compliance with the rule. And
All
that's
right.
what, it's a relatively useless rule, but you need to know how to apply it on the test. Okay. So any ad that contains the name of either the broker in charge or the name of the firm is in compliance. Any ad that does not is out of compliance. It doesn't matter how detailed or how good or how not detailed they are. That is the only rule that matters. Is everybody all right with that?
Mm-hmm.
Because I can almost assure you on the North Carolina specific section of the exam, you're going to have to identify which one of those ads is acceptable. So make sure you know what you're looking for. Be careful with that one, okay? We mentioned the Sherman Antitrust Act the other day, but it bears mentioning again what we're talking about here, what we mean by 2 different processes that are illegal. Price fixing and group boycotting, which are both things that cannot happen according to the Sherman Antitrust Act. And I should have added that into the slide here. I think I did in the other section, but you might want to add on your notes here. This is the Sherman Antitrust Act. That's the name of
Yes,
the law.
it was in the other side.
That's the name of the law that governs these type of activities. Now, the name of the activity which is not allowed is price fixing. Price fixing is an activity that should not happen if you are a real estate agent. And here's what price fixing means. Sorry, I just saw your message. Here's what price fixing means when you are dealing with real estate agents. Price fixing, as we mentioned the other day, was when real estate brokers or real estate firms make it sound as if what they are going to charge is somehow tied to what other offices are going to charge. Help me out here. Our office has a policy of charging everybody 6%. Allowable or not allowable?
Allowable.
Yes.
Allowable, absolutely.
Good job.
No, ma'am, I'm sorry. We cannot list your house for 5%. We don't charge less than 6% ever under any circumstances. Our firm does not negotiate down from 6%. Allowable or not allowable?
Allowable.
Yes.
Not allowable.
Allowable. Allowable.
Yes.
Allowable. And that's why I brought that specific one up. As long as you're willing to engage in the conversation, that's considered a negotiation. Just what we do not mean here that you have to be willing to change on your prices. You can tell somebody the price is not negotiable, but you have to be willing to admit that the price is negotiable if they go somewhere else. Does that make sense for everybody?
Yep.
Yes.
So as long as you keep it about your firm, can you say to a buyer, I'm sorry, we charge every buyer 3% and that's not negotiable for our office? Could we say that?
Yes.
Yeah.
Yes.
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 Can you say to a buyer, well, it really doesn't matter because you're not going to pay me anyway. I mean, all buyer's agents are going to be paid by the seller.
No.
it's not allowed.
No, not allowed, because you're not talking about your office. You're not talking about your firm. You don't know what other offices are doing. It's none of your business what other offices are doing. Is everybody with me on that?
Yep.
Mhm.
Yes.
And if anybody doesn't understand that, please let us know, because it is a very distinct reason why one would be allowable and why the other is not.
We can save you thousands by listing your home with us. We can save you thousands off the normal commission rates. Allowable or not allowable?
Not allowable.
Not allowable.
Not allowable, because how can you save me thousands off of the normal commission rates? Because there is no such thing as a normal commission rate. Does that make sense for everybody?
Yep.
Yes.
Okay. So anytime you're making those sort of comparative statements to other offices, it's not allowed. As long as the statement stays within your office, you're fine. It's when it's outside your office that you're out of bounds. Is everybody okay with that?
Yeah.
Mm-hmm.
Okay, good.
Question, can I ask a question?
Sure.
I thought price fixing can also be that you're with another broker from another firm, and you say to them, you're playing tennis or whatever, and after you go, well, so what are you guys getting for commission right now? And they say,
It absolutely can. That's gonna, and you have perfectly led me into the next part of that statement. So that's the part of price fixing we have to be careful about dealing with the buyers and sellers, the consumers. What we also can't do is have discussions with each other at different firms. Now, to be clear, can we have a commission discussion with people inside our firm?
yes,
Yes, because remember, ultimately, the firm is what's being hired by the client. So it makes sense to have discussions inside the firm so that people within the firm are being consistent and knowing what the policy is and all that sort of thing. Does that make sense for everybody?
Yes.
But here is what's not allowed. And folks, I cannot stress this enough. This is a felony. You could actually go to prison for this. You go to Cheesecake Factory for lunch with your best friend who works at Keller Williams when you work at Howard Perry Colwell Banker. You work at HPW, they work at Keller Williams, and you go to Cheesecake Factory for lunch, and you're sitting there at lunch and you're saying, what are you charging on your listings? Are you still doing 6%? I've dropped mine to 5% because I'm just trying to I can't get people to list. So I've dropped mine to 5%. What are you doing on your listings? You can go to prison for that conversation, folks.
Oh, my gosh.
That is felony price fixing, because again, you're having that discussion with people you're supposed to be competing with. You're not supposed to talk about your pricing with your competition. Does that make sense for everybody?
Yep.
Okay.
Yeah.
And that's the one that gets people in trouble right there. How many people do you think that work at different offices get together all the time and it's just a natural thing that the conversation gravitates toward?
Yes.
Yeah, you have to be really careful about that. Really careful about that. Okay. And there are every year real estate brokers who get in trouble with this. One of the most famous cases of real estate brokers getting in trouble with this are licensees. There were salespeople, most of them, not brokers, because they were in South Carolina. But they're in Easley, South Carolina. And if you've ever been to South Carolina or been to Easley, you know, they ain't much. It's right outside of Clemson. And Clemson's not much. It's near Greenville, South Carolina. But in Easley, South Carolina, at Denny's of all places, a group of local real estate agents used to get together once a month for like a club, like a Rotary type meeting. And there were several real estate agents in the group, and they would often discuss commissions and what they were seeing builders pay as commissions and what they were seeing other offices around town offer as buyer side commissions. In other words, they're sitting there going, have you seen Jake over at so-and-so? He's only paying 2% on his buyer side stuff. Do you think that's a pretty natural conversation to want to have with other people that work in your industry, folks?
yeah.
Yes.
Yes,
Yes.
it is.
Yes.
And guess who was sitting at the next table over from them every month because he went every day?
You were.
No.
Oh.
A retired FBI agent
Oh, my God.
Oh,
whose specialty at the FBI had been the Sherman Antitrust
Oh,
Act.
my goodness.
Oh, God.
And so he
Wrong place at the wrong time.
called his buddies in the Atlanta field office of the Federal Bureau of Investigation and said, you guys need to come have breakfast with me sometime and overhear these conversations that I hear on a regular basis.
Wow.
Folks, they charged 15 real estate agents with felony violations of the Sherman Antitrust Act for the conversation they had at Denny's.
Wow.
I ain't going to lunch with none of y'all.
Do not do that, right? Do not do that. And so Rachel said, how does that work when you're at one agency and you're switching to a new agency? How do you discuss commissions? Well, that's a really good question. if you are simply asking them what their policy is for the sake of you joining them, I think you're probably okay with that. But if you're just out in public or discussing it from the standpoint of, how do you compete with these people or how do you not compete with these people? That's not good, and especially don't put pressure on somebody else about commissions they pay. This is the one we have to pay attention to right now in our business. This is where people are getting in trouble right now. It is natural to get mad when you look at a transaction and realize they're not offering you as much compensation as you would like to make. That is a very natural reaction. Don't go on Facebook and put somebody on blast about, I can't believe Dan Ryan Builders is only paying $500 to buyer's agents. That's a felony. You can't do that. You cannot do it, because at the end of the day, here's what the federal government would say about your commissions. Who are you supposed to be having a conversation about commissions with? The one and only person you're supposed to have that conversation with.
The seller.
With your
Your
client.
buyer.
Your
Too.
client,
client.
right? Your
Right.
client, whether that's the seller or the buyer, whatever client you have, that's the one you have the conversation about commission with. And that from that point, you decide how you're going to get paid between you and your client. Are you going to get paid by the other side of the transaction? Is your client going to pay you directly? How is that pay going to work out? But you should not be putting that conversation out for public consumption. That's a law. Okay. Everybody okay on that? I feel like you have to talk your way through it to kind of get through your head what is not supposed to happen there. Are we all good with that?
Mhm.
So what would y'all say if you had to guess, what would you think the average buyer side commission is?
3%.
3%.
Uh-oh.
Felons.
Uh-oh.
Felons.
It's a trap.
See how easy that is? What's the answer?
I don't know.
There isn't
I have no
one.
idea.
no.
There is no such thing.
It depends.
I have no idea. There is no such thing. It's
There's no
whatever,
such thing as a regular.
it's whatever you
I don't
want
know.
to negotiate. There you go. It's easy to do it to you. It really is.
Yes.
And because it's easy to do. It's just easy to do. All right. The other no activity as far as the Sherman Antitrust Act. So again, this is still the Sherman Antitrust Act, same law. The other no activity from that law is something called group boycotting. Group boycotting basically happens when you work together with other offices. So again, it's about going outside of your office. When you collude or you work together with other offices to basically push somebody out of the market. Now, it is okay for you and your client to decide you're not going to look at a certain company's listings because your client, if a certain company is only paying 1% to bring them a buyer, and your buyer agency agreement calls for you to be paid 3%, and you've had this discussion with your buyer and they're like, listen, I don't want to pay you the 2% difference, so don't show me any of that company's listings. Is that okay for you and your client to have that discussion and them to make that decision that they don't want to see that company's listings? What do y'all think?
Yes.
Yes.
Yes. Yes, because they would be the ones paying the difference. There's nothing wrong with that. Is it okay for you to tell other people in the business, you shouldn't show so-and-so's listings because they only pay 1%?
No.
Nope.
No.
No.
No, that is called group boycotting. And group boycotting could happen because of other things other than commission as well. How about if there's a home inspector that is like particularly like nitpicky? They just like, they write up every single little thing and it makes your life a nightmare because it panics every buyer to death. And the buyer thinks they're buying a house that's going to fall down on them the minute they buy it. So they're all terminating their contracts and backing out. There might be a real temptation there to say, we're not going to use that inspector. Well, that's okay if it's just you and your office deciding not to use that inspector and you're discussing that with your clients. What would not be okay is you going to lunch and talking with somebody else who works at the firm across town. Have you had an inspection from Bob over at Bob's Inspections? He must have lost his mind. I don't know why nobody should use Bob. He is just crazy because he writes up no, don't do that. That's called group boycotting, because essentially what you're doing, it's okay for you to boycott somebody. Boycotting means we're not going to use this person. Can you decide, I don't like this service provider, we're not going to use this service provider? Can you make that decision? What do y'all think?
Yes.
Yes.
For sure. But you can't do it as a
Group.
You can't take other people from other offices and involve them in that conversation. It's like this big sort of, like mob mentality. Anytime you sort of start bringing in all these other people and engaging them with this thing, it's going to be a bad idea. Because remember, all those other people you're talking to are supposed to be your what?
Competition.
Competition. They're supposed to be your competition. If we all start scheming together with our competition, then the consumers really don't have a chance.
Yeah, it's like a monopoly.
It is a monopoly. And that's exactly what the law was designed to prevent, this monopolistic sort of behavior. Okay. Are we all good with those two things?
Mm-hmm.
Okay. Good deal. All right. So why don't we do this? Let's take a quick break, and I'm going to pause the video here for just a second. And when we come back, we're going to take a look. 4.2. 4.2 is the fair housing section, which is actually not 100% the breadth of it. It's fair housing, but it's all non-discrimination laws, all laws that deal with discriminatory behavior. I can't talk today in the real estate market, because some of them are only related to residential real estate, like the fair housing laws. And then you have some laws related to discrimination that cover all properties. The first one we want to talk about is the Civil Rights Act of 1866. And this is a law that governs or covers all property types. And it actually doesn't just cover real estate. It's not a real estate law. It's a law that's meant to really dictate how we interact with people in every aspect of our daily lives, in the sense that there is no limitation on this law. There's no, but it doesn't apply in this situation. This is the one non-discrimination law that we talk about in the whole class, which doesn't have any exceptions. So I think if you got a test question, and honestly, I don't think there's much of a chance of a test question about the Civil Rights Act of 1866. I think most of the test questions are going to center around the Fair Housing Act. But if you got a question on the test about the Civil Rights Act of 1866, I think it's going to center around this last bullet point right here, that there are no exceptions. There are no exemptions. There are no cases under which somebody can say, I don't have to follow the Civil Rights Act. I'm exempt from the Civil Rights Act. Every other law that we're going to talk about has some exemptions, some cases where people are allowed to not follow the law, but this one does not have that. This law, the Civil Rights Act of 1866, is always in effect. So what does it say? The Civil Rights Act of 1866 prevents the discrimination in any real estate setting, or really any setting, on the basis of race. It is always illegal, according to the Civil Rights Act of 1866, to provide a different level of service or refuse to provide service to someone in a real estate transaction on the basis of their race. Now, for purposes of this law, because you have to look at when it was passed, 1866, when they say race, that is going to be limited to color of skin and ethnicity, not nationality. This law does not govern nationality. We're going to talk about how that comes under the Fair Housing Act in just a second, but they're talking about specifically ethnicity here. And so this law only prevents discrimination. In other words, would it be a violation of the Civil Rights Act of 1866 to refuse to sell a house to someone because they are Jewish? What do you think?
No.
No.
No, Because that's
Not
discrimination
this
based on,
one.
that's discrimination based on what?
Religion.
Religion.
Nationality, religion.
Religion. Jewish is a religion. Judaism is
It's not
religion.
nationality, yes.
And,
People
and,
confuse.
and yeah, people do confuse it. It is a religious belief. So that would be discrimination based on religion. That is not what this law targets. And you have to focus in on that, because one of the most common mistakes that people make in the discrimination section of the class is just making the assumption that all discrimination is the same and it's all bad according to the law. The truth is, it's a lot more complex than that. Yes, all discrimination may be bad on a moral level, on an ethical level, but on a legal level, it's not all the same.
So something I really kind of want to hone in on what you said is that this Civil Rights Act of 1866 does not only apply to residential property.
Nope.
It is a law that affects all aspects of life here in the US. So when we get further into it, it's going to get more restrictive to this is only pertaining to these kinds of properties. And something that I really would love for you guys to kind of have in the back or the front or side of your mind as we're going into this is, remember how we were talking about our agency agreements? It has to have a non-discrimination clause. The things that we're going to talk about are the things that we can't discriminate against in
Yep.
those agency agreements.
So practical question for you. And you get a practical question. Would it be a violation of the Civil Rights Act of 1866 to refuse to represent a buyer because they are not a US citizen? Would that be a violation of the Civil Rights Act of 1866 to refuse to
No.
represent a buyer? because they're not a US
No,
No,
no, it's not nationality.
No,
Okay.
that would not be a violation. That would not be a violation. And that is tough, I think, for people to recognize and say on a test, because inherently, I think we want to say, well, yeah, you would never do that. But you got to recognize these laws have limitations. And this law specifically only prevents discrimination on the basis of one thing. And that one thing is specifically race. Is everybody okay with that?
Yes.
Okay. And that's the Civil Rights Act of 1866. Now, would this law make it illegal to, for example, not show a warehouse to someone because they are African American or Black? Would this law make that an illegal activity?
Yes.
Yes. And even though it's a warehouse, because one of the other things that we're going to have to recognize is the other laws that we're going to talk about mostly deal with housing. So they wouldn't cover that warehouse, but this one would. This one doesn't have any exceptions to it. It covers all types of property, all services that you may offer as a real estate agent. Never discriminate on the basis of what?
Race.
Race. And that's according to the Civil Rights Act of 1866. Everybody okay with that law? Are we good with this one? Okay, good.
Yeah.
Now we get to the one that is much more likely to impact you on a day-to-day basis in our business. The Federal Fair Housing Act. It is not called this by accident. Look at the word right here at the heart of the law, at the very center of the law. What kind of real estate does this law protect? What kind of real estate does this law say people should have access to equally?
houses.
Housing, residential.
Housing. Places where people are going to what?
Live.
Live. So as a practical question, folks, on the test, in the real world, Elizabeth is operating as a commercial real estate broker selling shopping centers. Blah, 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 yada, 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 don't care. Is this a violation of the Federal Fair Housing Act?
No.
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 No, it can't, no matter how nasty whatever she did was, no matter how awful blah, 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 yada, yada, yada was, it's not going to be a violation of the Federal Fair Housing Act because the property itself is not housing.
No housing.
And as simple as that sounds in this scenario, it is not as simple as it seems
Well,
to answer on
because
your
they
test.
throw it at you on the test because here's what happens. that yada, yada, yada stuff that I went past, they're going to give you some god awful, horrible scenario where
Get you
Elizabeth, and
all
obviously,
bent out of shape.
right, and obviously not our Elizabeth, because she would never do this, but where Elizabeth has refused to show a shopping center to a family because they are Islamic, and she tells them that she does not believe that their religion is a real religion, just all kinds of awfulness. And they
You
keep
get wrapped up in it.
and you get wrapped up in it, and you get emotionally charged by the content of the question. And then they say, is this a violation of the Federal Fair Housing Act? And the answer is still what?
No.
No.
No, because the thing is not housing. Does everybody see that? So the Federal Fair Housing Act is a law that's been around since 1968. It passed as part of the Civil Rights Act in 1968. It has been changed a couple of times. And it says that there are 7 protected groups of people that we have to be aware of when it comes to providing services related to housing. So again, this law would apply if we were showing single family homes. This law would apply if we were renting apartments. This law would apply, it's not just sales, it's sales and rentals. This law would apply if we were selling residential condominiums, but not office condominiums. So could we have buildings where this law applies in part of the building, but not in all of the building?
Yes.
Yes.
How many of y'all have been to like North Hills in Raleigh, or a mixed use development where they have like retail, shopping, restaurants on the first floor of a 10-floor building, and the upper 9 floors are all residential condos?
Yes.
Yeah,
So would the Fair Housing Act apply at all in that building?
yeah, in the top.
Yes.
Not all of it.
It applies, but not to all of the building. It would not apply on the first
Only
floor
housing.
where you've got the restaurants and the shopping centers and the grocery stores and all of those things, but it would apply to the 9 floors above with the residential condos. Does everybody see the difference?
Yes.
So it only applies to housing situations, and it's going to outline 7 protected groups. So now, before we talk about what the protected groups are, let's talk about what it means for a group to be protected under this law or have protected status. It says here that protected status means the topic cannot be discussed. So if the thing is on the list, and there are going to be 7 things on this list, we cannot even discuss those things. And that's going to be a big sort of bridge for you to cross mentally. People tend to think of discrimination as only being the negative variety of discrimination. And I'll give you an example of what I mean. I don't want to buy a house around Protestant families. Evangelicals make me feel weird. I don't want to be near them. Does that sound like a discriminatory type statement?
Yes.
Yes.
For sure. For sure. Is there a Protestant church in the area? Is there an evangelical church near? Because we would really like to be close to the church. Does that sound like a discriminatory statement?
Yes.
Yeah.
They both are the same thing.
Yes.
Even though one is said with a negative connotation and the other is said with a, oh, we would love to be near this. In the eyes of the law, they are equally violations. Does that make sense for everybody? Because when something is on that list of protected groups, it becomes completely off limits as a discussion topic for us as real estate brokers. Now, here's what I want to be clear about. Our clients, our customers, these buyers, these sellers, these landlords, these tenants, they are free to engage in whatever behavior they would like to engage in personally. They are not free to expect you or ask you to engage in illegal behavior on their behalf. We are the stopping point. It is our job, and the law makes it our job, to explain to our clients when they have crossed the line and to say, I'm sorry, I can't do that for you. In other words, it's not illegal for a buyer to say to you, oh, I'd like to be near, a Methodist church. It's not illegal for the buyer to say that. That might be their preference. They have their preferences and they're allowed to have their preferences. It's illegal for us to say, sure, I'll be glad to do that for you. Because we can't use that as a criteria. We can't allow that to be part of the discussion. Is that starting to sink in about what we mean about this is off limits, these things that are on this list?
Yeah.
Yes.
And I realize I haven't given you the list yet, but you can probably imagine some of the things that are on there, like religion, which is the one I've been hammering on here in the last few minutes. And I always like to point out, and I should have probably done this disclaimer at the beginning, I use these things for example purposes. These are not my beliefs or things I would say or things I would do in the real world. I have to show you how they're going to come out, how they could be said, both in positive and negative light, so that you can see what's not allowed. You can see where the line is. Otherwise, you won't.
And all discrimination is not illegal, by the way.
Yes, and that's exactly right. All discrimination may be bad morally, it may be awful ethically, it may be something we would never want to engage in ourselves personally. That doesn't mean it's illegal. It's only illegal if it's actually against the law. And so what we're trying to do is show you where the law is, where the law lies. Now, look at this last statement down here. Equal terms must be offered to all buyers and tenants. Equal. I want you to keep that in mind as we go through this, because we're going to give you some examples of things, and you're going to have to really challenge the way you think about, are we offering equal terms to everybody? And I'll just give you a quick example of that. Are there lots of buyers agents out there who probably won't show houses without having a written buyer agency agreement? In other words, they won't take you out to show you houses without having a written buyer agency agreement. What do y'all think?
Yes.
Yeah.
Yes.
And there's nothing wrong with having such a policy. Do you think it might be a problem, though, if you pick and choose which buyers you will show properties with an oral buyer agency agreement and which ones you require to have a written buyer agency agreement first? Do you think that might be a problem?
Absolutely.
That lack of consistency, folks, is absolutely going to be an issue, because then the question comes up, because here's what happens inevitably. If I'm a buyer's agent, and if Taj comes to me and says, hey, I'd like to see these two houses, and I say, Taj, that's great, I would love to represent you. I require a written buyer agency agreement before we can go look at property. And I put a written buyer agency agreement in front of her. Okay. She has that experience. And then I get a phone call the next week from Hilda, and Hilda wants to see a couple of houses. And I say, okay, Hilda, I'll meet you over there this afternoon. And then I go over there and I show Hilda the property, and we never talk about a written buyer agency agreement. Here's what I don't know. Taj and Hilda are friends. And they both talk about the fact that they went out looking at houses with Travis this weekend. And Taj says, yeah, I was really uncomfortable signing that agreement, but I didn't know what else to do because I wanted to look at houses. And Hilda goes, what agreement? Do you think immediately those people, whoever that person is, who's gotten the differentiated treatment, is going to start to internalize and wonder why was I treated differently? Why did I get a different answer than somebody else? Why wasn't it the same for me as it was for them? Is that a very natural question to ask, folks?
Absolutely.
Yes.
It is. And that is exactly the kind of thing you have to work really hard to eliminate from your business. You have to be consistent with people. It really doesn't matter what your policy is about having a written buyer agency agreement. It just matters that you apply it consistently across the board so that you are offering equal terms to everybody. When advertising, and this is going to be on the test for sure. This is a test. So much of what we talk about here is practical. So much of it is going to be test related as well, because I want to make sure, and people do get quite a number of fair housing related questions on tests, because it's an area we struggle with as real estate agents. This is one of my passions for teaching once people are licensed. I really relish the opportunity to teach these classes not because I think the material itself is fun. It actually can be very uncomfortable to talk about some of these issues in class, but I relish the opportunity because I think it's important to have uncomfortable conversations. I think it's important to talk about how if you have a certain policy and it impacts different people differently, then you need to take a look at your policy because something's wrong there. There's a disconnect. But when you, on the test, they're going to talk about advertising. Folks, things that seem practical may not be legal. As an example, let's say that you are listing a property in an area where you know that the vast majority of buyers are Hispanic and speak Spanish. Would it be a fair housing violation for you to choose deliberately to only place ads for that property in like local newspaper circulars and flyers that are printed in Spanish and available at the Hispanic markets in the area? Would that be a fair
Yes.
housing violation?
Yep.
Yes.
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 Because essentially, here's what's happening. You're not allowing the buyers to decide what the makeup of the neighborhood is going to be. You're deciding for them
Ordained.
Right.
because you're only choosing to market the property to one single demographic. Does that make sense for everybody?
Mm-hmm.
Right.
And so that's a case of we're not allowing consumers to choose there. The real estate broker is making the choice for the consumer. And we're saying this is the house that's available to you because this is the one we're going to market to you. And by the way, if we didn't market it to you, it's not for you. No. So we have to make sure our advertising hits as many languages as possible in an area, as many religions, or none at all. Now, here's what I'll say about the language thing. It's never going to be a violation to only advertise in English because it is accepted that English is the spoken language of our contracts, of our marketing, of our license law, of our entire system of government. That's not to defend that stance. It's just to say that would not be considered a fair housing violation. So while advertising only in Spanish might be considered a fair housing violation, advertising only in English would not be, because there has to be some baseline. Again, that's not my policy, but that's the way they enforce it. Everybody all right with that?
Mm-hmm.
Okay.
And that's if you only do that, right? You can do both.
That's right. You can only do, you can only do English, but if you're only going to do one, English better be the only one. If you're going to start to reach out, make sure that you are reaching out to as broad of an audience as you possibly can. When you start, don't, in other words, single out and say, oh, well, I'm going to put this one. And here's another thing don't do. Don't put that one property in the circular that's available at the Hispanic markets. If you're going to advertise your listings in the circular at the Hispanic market, which listing should you advertise?
All of them.
All of them. Every single one you got. Because if you're picking and choosing and saying, oh, well, I'm going to only advertise this listing in this newspaper, again, aren't you picking and choosing what those people have access to?
Yep.
And so you have to be really conscious about the choices you make when it comes to the way we market these things, because we really have to be careful. Look at this last one down here. And this is why I told you, got to be careful to do the same thing for everybody. You're a property manager. Somebody comes to visit the property that's in a wheelchair. First thing out of your mouth is, we have a first floor unit. It'd be perfect for you. Would you like to take a look at it? Now, folks, I don't think anybody who says that is saying it with malice or with a ill will in their heart. In fact, I think most people who say something like that are probably trying to be nice and helpful. What do y'all think?
Yeah.
Mhm.
That's
Yeah.
something
Yes.
I would probably think of doing if I didn't know this.
It doesn't mean they haven't discriminated against that consumer, because what you've done is essentially said to them, because of your handicap, you can only look at these first floor units. I've picked the unit for you. You don't need to pick your own unit. Isn't that sort of insulting to not allow somebody else to make the choice themselves?
100%.
right? And so we have to be very conscious of that, because here's the thing. For all I know, that person may prefer an upper floor unit. Maybe they have some other reason they prefer an upper floor unit, and maybe they plan to pay to have an elevator put in, which they can do, by the way. And so I'm not allowed to pick and choose for them. Now, do not confuse it with this. Can they say to me, I would prefer to see only your first floor units? Can the consumer say that to me?
Mhm.
Yes,
Yes.
Yes,
And then can I show them only first floor units?
yes.
absolutely.
Because folks, isn't that exactly what I would do with any potential tenant, handicapped or not, who came into my office and said, I only want to see first floor units?
Yep.
Yes, sir.
Sure, I would. That's all.
When you're,
Now,
when you're interviewing them, can you ask them?
I think
Do
that's a
you
good
have a
question.
floor preference, or do you have
I
a?
think that's a good question, Elizabeth, and I'm going to say the answer is it depends. Are you asking everyone that question?
Okay,
Because if that's a standard question that you ask every tenant that comes in, do you have a preference of floors? Then clearly you're giving the same terms, the same conditions to that person. But again, if it is, oh, well, do you have a preference of floor? And you don't ask that to the other 72 people who just came to the door. You just happen to ask that to the one person who's in a wheelchair. Have you changed your service based on their handicap?
yes, you have.
You have, and therefore you've discriminated.
Mhm.
I have a
now
question.
I do. Go ahead. Go ahead.
So I have a friend that lives in an apartment building, and their first floor is like made for just handicapped people, and they refuse to show them any units on the first floor because they're not handicapped. Is that like the same kind of thing? Like, were they legally supposed to show them the bottom units even if they didn't qualify?
So there's
A
no,
really
well,
good example.
it's a really good question.
Mhm.
I would say that definitely errs in the direction of being discriminatory on the basis of not having a handicap, which, remember, either direction of these is wrong. What I would say is that any facility that has those kinds of units available, which are specifically outfitted for those with disabilities, would be fine to withhold those units until specifically needed, as long as they have other units available to show someone. But if somebody like your friend comes in and says, well, I'd like a first floor unit, and they say, well, I'm sorry, the only ones we have are for people with disabilities, have we discriminated against them because of their absence of a disability?
Yes.
Yes, we have.
Yes, we have. And so
Yes, we
that's
have.
going to be a problem as well.
Yes. And you don't know that, you can't assume because the person's in the wheelchair that they are handicapped. They may be able to physically make it down one flight of stairs by
Sure.
supporting themselves. So you've automatically decided for them what they are or who they are.
And
You can't do that.
how they can do and what they
Yes.
can do. And you've dictated
Right.
so many things about these choices. They're just unfair. Listen, so much of this is born out of wanting to be helpful. And that's where we have to,
Mhm.
and that's why I say this is a real passion of mine in teaching this to people who have licenses out there, because I don't try to judge people with this stuff, because I really believe that 90% of the fair housing violations we have are not born out of bad intentions. They're born
of
out of,
goodwill.
I'm not stopping to think about what I'm doing. I'm not stopping to think about the impact of what I'm doing. Okay.
And one thing, and I think this chapter actually gets like a lot of engagement because it is such a crazy thing to talk about. You just wouldn't think these things are discrimination. But one of the things that I wanted to ask you about is, how you had mentioned, putting a listing on that only in a Spanish newspaper. Would just putting it in the MLS cover this?
I would say
Cover us.
I would not say not necessarily, because again, why did you specifically choose that newspaper? What are you specifically targeting that group of people? Is now, if you say, well, I always advertise in this newspaper because it's the most effective advertising in this area, so all my listings go in this newspaper, you'd probably be okay. But if you were singling out that one listing and saying, oh, well, I got to put this one in, that circular, you're gonna have a problem.
Right,
So,
and not
but-
everybody has access to the MLS.
True.
That's true. And so, but if we didn't put it in the newspaper and just put it in the MLS, this would probably prevent the
That's right.
discrimination.
Because again, now you're saying I handle everything the same. They all go in the MLS and they all get propagated from there to all these different websites. And so I'm basically blasting this thing out to the greatest extent I possibly can. And then you don't have to
Okay.
worry about that because you're treating them all the same. Okay.
Makes sense.
Travis, excuse me. I just recently saw an ad that says that our 80% of our clients are lightings. That's a violation.
Now, what was the ad for?
Real estate.
Yes, huge.
Says our
Huge.
80% of our clients are Hispanic.
Yeah,
Yes,
huge violation. No question.
yes.
Even saying that would
Thank you.
saying we speak Spanish be a
No, saying
No.
Spanish is a
And that
factual
also-
statement. It's a factual statement, just simply letting people know that you can provide them information in that language. You're not indicating a preference that you would only deal with people of that language or that you would
Okay.
offer different terms to people that speak a different language.
Heard.
So that that should not be an issue. That
So you
should
can
not be
just
an-
put.
If
see
anything,
how
you're being
less
more
than-
inclusive.
What was that,
If you-
Elizabeth?
You can say, you can put on the ad, si habla español, right?
Yes, right. As long as you don't. Now, what I would not do is have business cards that were solely in Spanish. And I certainly would not have two versions of a business card, one that was in Spanish and one that was in English, and pick and choose who I gave said business cards to. That would be a problem. So again, equality of treatment is the goal. So if you want to have a business card that has your name, your firm's name in English, because that's the accepted language of our contracting here, and then you want to say hablamos español, you know, to point out that yes, we can communicate in this language, or and it doesn't have to be Spanish. I just that's the only one I know how to say. I speak this language, you know, parlez-vous français? I guess you can put a
Me
business,
too. I only know it.
you know, speaking as Deutsch, I guess, right? You know, I guess probably do know it in several, I guess. But you could put that on the card as additional information.
Right. And they can ask for if you have literature or the information in Spanish, and that's okay for them to ask you.
Sure, of course, because they're trying to engage as best they possibly can. And Danae, I think having English on front, Spanish on back would be absolutely acceptable, right? Because you're providing extra information and not in any sort of a way trying to say we're limited to this target market here.
Hey, I have a quick question.
Okay, go ahead, Taj. I'm sorry.
The phrase our target market, the phrase our target audience, in this particular section would definitely be discriminatory. So if I want to target people in a certain bracket who makes a certain type of money, and I target only people in Ballantyne, only people in Dilworth, only people in Charlotte, would that be discriminatory if that is my target audience?
So what a wonderful question, given the slide we're on right now. Here are the 7 protected groups. So we're going to answer Taj's question by looking at the list, because Taj has asked a wonderful question. What if I'm targeting people based on income level? Is that acceptable? Well, folks, there are 7 unacceptable reasons to target people. And they are, and so why do I have a picture of corn up? Because fresh corn is the way to remember this. Write out the words fresh corn, and then the E and O, you're just going to make equal opportunity out of. Okay. So you fill those in first, and then that'll leave you with the other letters, the other 7 letters that you're going to use to remind yourself of what the protected classes are for fair housing. They are familial status, and we're going to talk about individually what these are, okay? Some of them are self-explanatory and some are not. They are familial status, race, sex, handicap or disability, color, religion, and national origin. So now, Taj, I want to revisit your question. You asked me, would it be a violation of the Federal Fair Housing Act to target people based on income. What do y'all think looking at this list? Is income level
No.
on this list?
No.
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 So targeting advertising based on income level. So therefore, would it be a fair housing violation, as an example, to place an ad in a magazine that for a let's say you have a $2 million listing and the magazine targets as their, their readership demographic, people who make more than $250,000 a year? Would that probably be considered a fair housing violation or not?
Yes.
No.
No,
Uh,
No,
because
no.
how are they targeting people? Based
sorry,
on
got it backwards.
income, right? And income is not on this list. And that's what and that brings us to the next slide. All discrimination, all targeting, all grouping is not illegal. There will be many, many examples of grouping, targeting, saying this is our target audience, that are absolutely legal. But then there are how many examples of ones that are illegal? How many?
7.
7. There are 7 reasons that we cannot target or group people together. Okay. Now, Mary, to your question, we don't serve all people equally. That is different than saying give all people equal service as it relates to these 7 things. These 7 things, only these 7 are the ones that are illegal. Now, I am not telling you to go out and discriminate against. Now, I'm going to be honest with you. Y'all ready for some real heart-to-heart honesty here?
Yes.
Yes.
There's one near and dear to my heart that ain't on this list, folks. Could a real estate agent tell Drew and I'm not showing you a house because I find the fact that you're a same-sex couple to be disgusting?
Yes.
Could a real
Yeah.
estate
Yep.
agent legally,
Yes.
within
legal.
their rights, based on this list, do that?
Yes.
Yeah.
Damn thing that can be done about it, unfortunately.
It's not on the list, folks.
Didn't they add it to the list? I thought they added it.
So we are currently in the process of, HUD is looking at redefining sex, and the proposed redefinition of sex, which hasn't been passed into law yet, would include sexual orientation and gender identity. But as of currently, sex literally just means gender, biological gender. That's all it means. And that's all that's protected. And so I bring that up as a point, not because I think and hope people are discriminating, but because we have to accept, especially for test taking purposes, are there going to be actions that we individually find morally and ethically wrong on a personal level that are not going to be actually illegal? What do y'all think?
Yes.
Yes.
Absolutely.
Yes.
100%.
And that's what we have to be really super careful of. Now, I'm not telling you we can get out in the real world to only be nice to these 7 people. I hope you don't discriminate against anybody for any reason. That is my sincere hope. But at the same time, you're going to be taking a test and they're going to want you to know what's the line in the sand of legality. So we have to be really careful about that.
Wouldn't you, as a married couple, Travis, be under familial status?
That's
Well,
what they're trying to fight for.
Really great question. Not under familial status, and we're not married. So even if it was, we would not be.
Okay, then there's that. Then there's that.
We're those people that have been engaged for like 10 years and we just don't ever get around to doing it. It's like,
Do it.
I'm trying to put it off until I'm dead.
Wow.
No, I'm kidding. Kidding. So look at some of the things that are not protected. And this is a big one. This is going to come up on the test, folks. People don't realize this is not on the list. They look at the list, and you shouldn't really look at the list and go, oh, it's good this is on here. You should look at the list and go, whoa, there's some things on here that probably should be. Can we all agree on a moral and ethical level the following statement would really be pretty bad? I'm not showing you houses, you old ass. I don't deal with old people.
Mhm.
Can we
Yeah.
all agree that that's a pretty nasty statement?
Yeah.
It is.
Absolutely.
Yes.
It's not an illegal one, folks.
I can tell.
Damn.
That's the sad part.
It's not illegal. It's not, I mean, I keep going back to that list. It's not there. It's just not there. And so,
So is that how they can have the 50 and over?
well, people jump to that, but hold on to that, Rachel. That
Okay.
actually has something that, it has nothing to do with 55 and up communities.
Okay.
We're getting there, and I get why you asked that. That's the one that people automatically jump to, but that it really doesn't actually relate to age. That relates to something else. But
Okay.
we're gonna get there.
What about children? Can you discriminate against people that have children? I don't see that on the list.
That's what this one is. Familial status, the one you asked about earlier, actually has nothing to do with marriage, and it has nothing to do with the family unit that's in that house. Familial status refers to, and this is the one you're going to need to kind of memorize and hammer into your brain. Familial status means one thing is protected about that family, whether or not they have children. It's not
So
just
weird.
the children that are protected. It is the fact that they have them or don't have them that is protected. In other words, it is not okay to talk to somebody about whether an area is good or bad for who?
Their
Children.
children.
For children. It is not okay to market to people and say, how about this? How about this advertisement? Perfect for empty nesters. Define what an empty nester is for me, folks.
Kids went off.
Somebody who
Kids
doesn't
grown
have
up moved
kids.
away.
People who no longer have what?
Children.
Kids living at
Children in
home.
their household. That is a clear violation of the Federal Fair Housing Act because you are.
I had a very long debate with somebody about this one day, and they had just recently started a team, and they were going around the house on a live Facebook feed, and it said, "We have a nice room over here to our right. It's perfect for a kid's playroom." And I was
No.
like,
It's not perfect for a kid's playroom because nothing in that house is perfect for that thing you just talked about.
right. I was like, all right, I'm gonna let you think whatever you
At
want.
least from our perspective, are the buyers and sellers going to have their own opinions about, oh, this would be perfect for my kids?
Yep.
Yes.
Yeah.
Of course they are, and they should. They're your kids. But that's what I remind myself. They're not my kids. It's not my job to decide if this is the neighborhood for them or not the neighborhood for them, or a good house for kids or not a good house for kids. That is your job as their parent to decide. So here's the thing. If somebody says to you, well, I need a house that's good for kids, you need to get a follow-up information from them, because here's what you need to say to them. You know, as crazy as it sounds, I actually can't do that. Number one, I can't talk about your children. Number two, I don't know what you mean. I don't know what your vision of perfect is, but if you'll tell me what you think is the right mix of things in a house, I will be glad to find them for you. In other words, can you look for a house that has a playground in the backyard?
No.
Yeah.
Yeah, if they tell you specifically.
Yeah.
Sure
Yes.
you can. If they
Yes.
say I want to play set in the backyard, of course you can. That's just because here's the thing. I don't know if they want it for kids or not. Maybe they're a 50-year-old man that wants to go swing at 3 o'clock in the morning. I don't know. That's not my business. That's not my business. And the other one that hangs people up. I'm sorry, go ahead.
No, you're good. I was just gonna say, Tyler points out something very, very evident, and something that was kind of on the front of my mind too. I feel like agents do this daily on accident. It's gonna be very hard for people not to feel sort of betrayed or, you know, some kind of way if they can't talk about their kids when they're buying a house. It's
That's exactly right. And here's the thing. They can talk about their children, and they will talk about their children. There is no doubt about it. Their children are the focal point of their life in many ways. We have to filter all that out, and we just should let them know, hey, you talk about what you want to. I want you to buy the house you're comfortable with, everything to be what you want it to be, what you need it to be. But ultimately, I'm not allowed to make decisions one way or another about children as a factor. I'm just not allowed to do that. Here's the thing though. If you see something you're concerned about, let me know. And we'll see if we can address that. You want to make sure that, and so here it is, it's exactly where I was headed.
Yep.
Because people
Love it.
love to jump to tangents. People love to, and Mary, I'm gonna pick on your comment, Mary, because I love it because you set me up. But people jump to tangents. Folks, children and schools are two different things. Just because children are off limits for us as a topic of discussion does not mean schools are off limit for us as a topic of discussion. And let me explain to you why that is. I don't have children. On a personal level, I don't care how good or bad the Wake County schools are because I don't have children in the Wake County schools. Does that make sense for everybody?
Mhm.
Yes.
But as a homeowner and home buyer, is it a huge deal to me that I feel that the Wake County schools are of a high quality because I know that's going to carry market value and weight when I get ready to sell this thing?
Yep.
Yes.
So here's the thing. In other words, are schools important to everybody, whether they have children or not in some way?
Yes.
And that's why it is absolutely within reason to discuss schools and absolutely a topic. But now don't start tying the schools together with their
Correct.
children. If they say things like, well, you know, my son has this learning disability, are the schools around here good for that? That's too close to home, folks. That's too much. You've now tied. So here's what you need to do. You need to say to them, you know, I can't really answer specific questions about the schools because I'm not that knowledgeable, but I'll be glad to put you in touch with people at the schools who are. Did you notice that I navigated that question entirely and never once talked about what?
Children.
Their
Children.
child. Did I ever mention their child at all? Even though they did I do it?
No.
No.
No, I did not. And I talked about the thing that I could talk about, which was the schools.
Can I ask you something?
Sure, of course.
So I'm on a mom's group for Raleigh, and there's a woman that markets that she's a realtor and she specializes in finding school districts that are good for people's children.
No. Now she can specialize in finding school districts. If somebody comes to her and says, I want this school district. I've done that 1,000 times in my career. You know, when I started in this business, my office was in Chapel Hill. And when you work the Chapel Hill market, here's what you quickly come to realize: schools are a huge deal over there because you can have Chapel Hill addresses in 3 different counties and 3 different school districts. You can have Chapel Hill address with Chapel Hill City Schools. You can have a Chapel Hill address with Chatham County Schools, and you can have a Chapel Hill address with Durham County Schools. And every one of those folks is going to have a different buyer, different profile, different price point. I can't. So here's the difference. When somebody comes to me and says, well, we want to be in Chapel Hill, I can't say to them, well, you know, depending on where you want to have your kids in school, we need to figure out which school district you want to look in, because now we're focusing on their what?
Children.
On their children. But I can say to them, okay, are you okay with any of the 3 school districts that Chapel Hill falls within, or would you prefer to look at one school district? Have I essentially asked them to guide me in the direction they want me to head without talking about the thing that's off limits?
Yep.
Yes.
Yes.
You know, I don't want to break your chain of thought, but I know Tyler had asked, and Zoe are along the same line, what if they ask, hey, would this house be good for kids? Can you answer that?
And the answer is no. The answer is no, because number one, how am I going to possibly answer that question without talking about their children or without talking about children as a topic? And I can't talk about children as a topic. So I can't possibly give my opinion. The other reason why I think it's inappropriate, forget fair housing for a second, I don't know what good for children is.
Yeah, what does that mean?
I don't have them. I don't like them very much.
What does that mean What does a good neighborhood for kids mean? That could be
That's
different for
subjective.
everybody.
That's it.
Right.
We can't talk about
I
it.
do actually like kids. I just like them when I can send them home when they get annoying. I'm a
Right.
really good fun uncle, but I'm not,
But you don't have to say to them, I can't talk about that. You can say, tell me more what that means for you.
Right.
Right?
I think if they keep directing you right back at kids, but what about my kids? But are you telling me there are a lot of kids in the neighborhood? I think there comes a point where you have to say, that's a topic I can't discuss. But I think for the first question, if you can redirect them more toward what because here's the thing. In my experience, when somebody says to me the generic sort of, is this a good neighborhood for kids? They already have in their mind what that actually looks like. You just need to get them to spit it out. You need to get them to say what that looks like. And so if I redirect them and say, well, can you give me an idea of what specific things about the neighborhood you're looking for? Notice I have taken the conversation off of those people that they mentioned and redirected it to the property that I'm supposed to be helping them find. Does that make sense for everybody?
Yes.
And so when I say, well, can you tell me specifically about the property, like what you want? And they're like, well, we would need a neighborhood that has a playground, obviously. Can I look for neighborhoods that have playgrounds, folks?
Yes.
Absolutely.
Yes, because that's just a fact of the neighborhood.
I'm so glad you brought it back to that, because I think, during the midst of all this, when we're talking about it, we just hone in on, we can't talk about kids. So, as long as you're turning it around and saying, well, tell me what that means for the neighborhood for you. What are you looking for in your house?
Yes. Because again,
That's how we would respond.
It's all about, and if you get back to this root idea, who's supposed to be making the choice here?
They are.
The client.
They are.
The buyer.
They are. As long as I'm giving and expressing my opinion about what neighborhood's good for kids, ultimately I'm making the choice. I'm not supposed to be doing that. They're supposed to be making the choice. If they can line it up for me and say, well, it needs to be 2,500 square feet. It needs to have a bonus room because the kids need somewhere to play. And I would like to have a second office because they might have virtual school on some days. Those are all criteria I can be writing down. I don't care what you're going to use the bonus room for. I don't care what you're going to use the second office for. I don't care what you're going to use the playground for. I just know you need a house in a neighborhood that has a playground with 2,500 square feet, a bonus room, and a second office. Boom.
That's all you're hearing. And you're not talking about the kids. So, and it can be quite awkward, especially, if somebody's talking about it at an open house and you're talking to a customer, especially if it's your first couple of times, like telling somebody, hey, I can't talk about that. But you kind of get a good feel for it.
You do. Do y'all see why these discussions take a while, why this kind of chapter moves slow? Are you starting to kind of evolve a little bit different idea of your approach here? It's constantly redirecting. And I will tell you, for me, this was my saving grace as a broker in charge with teaching my agents how to deal with fair housing laws effectively and also represent their clients in the best possible way. Our job is to talk about property, not about people. That's my golden rule of residential real estate. Our job is to talk about property, not about people. If they're asking me about the people that live around them, the people that are going to be near them, the people who are going to be in the house with them, the people who are in the neighborhood, that's a no-go zone for me. But if they're asking me about the property, yes, that's what I'm here for. Does that make sense for everybody?
Yes, absolutely.
That's my job. Talk about property.
I'm good at that.
Exactly. Okay. I will say this. On the test, they like to get nitpicky with you about, can we limit the total number of adults and children in a unit? And the answer is yes, because when we're limiting the total number of adults and children, that's another way of saying limiting the total number of people. Do you think we can enforce an occupancy limit on rental property in particular? What do y'all think?
Yes.
Yes.
Yes. What we can't do is give a specific breakdown of how that works. As an example, if the maximum occupancy of a property is 4 people, we can't say, 2 adults and 2 children. We just have to say 4 people, and they have to figure out whatever the mix is among that. Does that make sense for everybody?
Yes.
So that could be 3 children and 1 adult, it could be 3 adults and 1 child, it could be 2 adults and 2, it could be any mixture within there as long as it's bodies. That's exactly right. Heartbeats. That's the way HUD refers to them, as heartbeats. That's what we're allowed to enforce, the number of heartbeats. And so what you will find is HUD's rule, and it's the one I suggest you memorize. HUD's rule is 2 heartbeats per bedroom. That's a reasonable occupancy limit. So that means if you're renting a 4-bedroom house, what should you probably give as the most restrictive occupancy limit? You can always go higher, but don't go less than what? If you're renting a 4-bedroom house, total number of people.
8.
8 people. 8 people. If you're renting a 3-bedroom apartment, what's the most restrictive you should be?
6.
6.
6 people. 2 per bedroom.
Okay.
Per bedroom. But don't get into the mix of like, because here's what's going to happen, and this is going to get people in fair housing trouble. If you're a residential property manager, if you're running an apartment complex, and you're renting a 3-bedroom apartment, might you be concerned? And let's just get down to brass tacks here. Might you be concerned about somebody who shows up as a single parent with 5 children, ages 4 through 10, living with them? Might you be like, have some concerns in the back of your mind about, holy crap, they're going to have 5 kids in this 3-bedroom apartment? Are those concerns that are going to pop up in the back of your mind if we're being honest with ourselves?
Yes.
Yes. Don't voice those concerns.
Wear and tear, huh?
Don't say that, because if that's a 3-bedroom, they're allowed how many people?
2 per
6.
bedroom.
People.
6. And if that's 1 adult and 5 kids, that's 6 people.
Mhm.
Okay. So, that's the kind of things we have to really discipline ourselves out of. How are we all feeling about that familial status one? Pretty good?
Yes.
Yes.
I think that one is the one that gets people in trouble, because the name is not self-explanatory, number one. And number two, because children are such an essential part of the search process for so many people. I mean, so many people look at it and they are basing their search around, what works for their children. So some examples of discriminating based on familial status. We're still talking about the familial status one. Refusing to rent to a family who has children. Or even saying, would this be a violation? We would love to find a nice young family with children to buy our house. Would that be a fair housing violation if a real estate broker did it?
Absolutely.
Yes.
Yeah.
It's not just saying we don't want them, it's also saying we do want them. Either way. Saying that this neighborhood is great for kids, suggesting that they would or would not prefer to be in this area because of the kids or because they're not kids, all of that would be wrong. Also, don't ask them if they have children. You should never ask that question to a residential buyer or seller, because in their mind, all of a sudden, here's the thing. We don't want them to think they need to be guarded about, can you imagine if you were showing a buyer around and you ask them if they had children, and in the back of their mind, they're thinking, well, if I tell him I do have children, is he going to show me different houses? That's why you don't ask. That's why you don't ask. Now, they may volunteer, and if they do, that's fine. And if they volunteer and they just want to talk about their kids and soccer practice and all that, that is casual conversation. When we say don't talk about children, we mean specifically as it relates to this real estate transaction. Because it's very hard to talk to some people and not talk about their children. I will tell you, as far as I know, it's not discriminatory to lock a child outside during a showing. And I hope it never does become discriminatory, because I have been known to do it.
Oh.
Because they tear up stuff.
Travis, I agree.
I always make sure the backyard's fenced in first. But if the backyard's fenced in, they always accidentally get locked outside when we're and then I let them back in before we leave. But no, I'm kidding. I've only done that once. I really did it once to one kid. He was awful. It was awful. You want to know what's funny? He bought a house from me like 3 years ago. I locked him out of the house when I was helping his parents buy a house all those years ago. And here he comes back full circle and buys a house from me.
That's hilarious.
That's when you've been doing this too long.
Did he remember you locking him out?
Yes. Yes, he did. And you know what he said? He's like, I'd have locked me out too. I'm like, yeah. Because here's what he was doing. I'll never forget. They had one of these racks in the wall with the keys on it. And they, and I don't know why they had so many keys up there, but he had every key and he's running around the house, shoving them indoors and like trying to unlock every door. And I had no idea what he was doing it until I see like 3 keys sticking out of doors that he had left behind him around. And he's like going around it. And so then I took the keys from him and I hung them back on the thing. I said, no, don't do that. And his parents are wandering around looking at everything else. They expect me to be looking after him, I guess. And the next thing I know is he has this wood, it looked like an ashtray. It wasn't an ashtray. I don't know what it was, a wood bowl of some kind. And he is banging it on the coffee table. And I looked and I listened, I did not have a plan to lock the child outside, but I looked outside and there was a swing set out there. And I said, buddy, why don't you go check out the swings? And I looked, and when I opened the door to let him go outside, I looked around and the yard was fenced in and the gate was closed. And I closed the door.
You had to keep
And
the
now
air conditioning
I was not thinking to lock him outside. I just closed the door. It was one of those doors that's always locked from the outside, which you learn to hate in the real estate business anyway, because that's why you always keep the key in your pocket so you don't get locked out in the backyard. Well, next thing I know, 5 minutes later, I hear him banging on the door. I act like I didn't hear him. I really did. I left him locked outside for the rest of the show because I was like, no, you're not coming back in here. You're not, no.
I don't blame
you. How about handicapping status? Handicapping status is a protected class. So when you see this buyer, what properties would you show him or send him?
All of them.
There you go. All of them. Every single one. Would you send him the 3-level townhouse with 8,000 stairs from y'all know the ones I'm talking about? You'll learn to hate those too in this industry. Lord help me, a 3-level townhouse. I hope I never show another one the rest of my life.
Nice.
Where you go in.
And they ain't ever got no air conditioner on.
And it's got the garage and like one room on the first floor. And then you go up a level of stairs and that's where like the kitchen and dining room and living room, they all have the same floor plan. And then you go up another level and that's when they have 2 bedrooms up there. God knows I hate them. That's too many steps. If I lived in one of those, I'd never go to my car ever again. That's too far. That's too far.
I found that they're hard to sell.
And so listen, I've just gotten old and fat. I go in the front door and I'll make it up to the main level and I just lean on the banister and I'm like, y'all can check it out. I'll be right here if you have any questions. I'm not going up there.
I sold a nice one though in Cary. I really liked it. I would have bought it if I could.
In my younger days, I would have too, but not anymore. But here's the thing. Do we send John those 3-level townhouses?
Yeah.
We did.
Yes. Unless John asks us not to. Unless John gives us a preference and says, well, I'd like a first floor master. And I realize that
can't say master anymore.
Well, there's a lot of debate about that. HUD hasn't said we can't. There are certain MLS systems that have said that. So it's an interesting sort of debate. But, if I do think there is the potential here where your client could sort of go, really? Why are you sending me 3-floor deals? You see my situation. If that were to happen, because I've had people bring that up to me, well, I don't want my client to think I'm not sympathetic to their needs. First of all, I don't think they're going to say that because I think they're going to very quickly shut you down and say, well, I don't want this. I'd rather have something that's 1 level, if that's what they want. But if they did, I think you just very quickly respond to them and say, I completely understand. I have just learned over the years that it's not my choice. I always send everybody all the options. And I figure you will tell me what you want and what you don't want because it's not my job to choose for you. That completely diffuses the situation. It really does. It's such a powerful statement. And it's the exact truth of the situation. And which is that they should be making the choice. The thing to remember about handicapping status and disability is that not all disabilities are visible. As a matter of fact, the vast majority of disabilities are not visible. They can be physical, of course, and even the physical ones can vary from illness to even, things like vision issues or hearing issues. But also you could have people who have addiction
PTSD.
issues, PTSD, alcoholism, drug dependency. All of those are considered handicapping conditions under federal law. So we have to be really conscious of the fact that handicap and disability can be presented to us in a number of different ways. And the basic reality is this: if someone comes to you and they say that they are handicapped, then treat them as if they are handicapped. Treat them as if they have that disability because they've identified it to you. Don't treat them as if they have a disability because you decided that they do, but because they have asked you to recognize that disability, and then you will be fine.
Right. So if the handicap example that you were talking about, if he asked for only first floor properties and no 3-story townhomes, then that would be something we could accommodate.
That's
right?
exactly right, because that's exactly what I would do for any buyer. There are plenty of buyers who don't have a disability that'll look at they look at one of those 3-floor townhomes and they go, no, that's not for me.
Yeah.
And so you would eliminate that from the search just like you would anybody else. It is important that you never ask someone what is wrong with them. If they are willing to provide any written documentation that they have a handicap, that they have a disability, and that written documentation can come from a doctor, it can come from a social worker, it can come from a nurse that they have been under the care of, it can come from a psychiatrist, a psychologist. I mean, there's all kinds of sources for that thing. But if you yes, Seth every day, exactly. If you start digging into their medical history, you've gone too far. If someone identifies as having a handicap, number one, I probably wouldn't challenge them any further than that. But sometimes landlords do find themselves in the need of saying, okay, can you document that? Because the person may be asking for some pretty large concession or some change in things. If there is the necessity to document the handicap, accept whatever written documentation they're willing to provide. Does that make sense for everybody? And the documentation doesn't even have to say what the handicap is. It just needs to simply say, Seth is handicapped, whatever that is. It doesn't have to be a visible handicap. It could be whatever.
Now, if you're renting to someone who is handicapped, do you have to provide ramps and grab bars and toilet heights and all of that?
Great question, because that's exactly what we're about to talk about. We're about to talk about what type of accommodations that we need to make. What kind of accommodations do we need to allow, which can include very simple adjustments. You need to know this vocabulary word for the test taking purposes, by the way, an accommodation. An accommodation, and yes, Seth, we are. An accommodation is a change in our policy based on someone's handicap. So as an example, look at this parking space right here. If we found that we had 2 people in the building who required a disability parking access, could we simply change another one of those spaces to be used for disability parking?
Yep.
What do y'all think? And that would be a reasonable accommodation. It doesn't require any change to the physical property at all. It just requires a change to how we operate. Let's say our office is on the 2nd floor of a building that doesn't have an elevator, and the tenant wants to come in and meet with us. Could we make arrangements to meet with the tenant somewhere else that doesn't require stairs?
Yes.
Yes, that would be a reasonable accommodation. Those are all examples of accommodations. Now, we are required by law to make reasonable accommodations when they are requested by someone with a handicap, someone with a disability. I do want to point out to you, an accommodation is not changing the property. Everybody with me on that? So we're not talking about yet, we're not talking about things like ramps or changing out tubs or doing everything. We're not talking about construction projects. Accommodations do not require a hammer. They don't require construction. Accommodations are just changes in policies. Is everybody okay with that?
Yep.
And so we are required by law to make reasonable accommodations. Now, Summer, I'm going to point out something to you. Summer mentioned the Americans with Disabilities Act. We're actually not talking about the Americans with Disabilities Act, Summer. And here's the reason why. We are going to talk about the ADA, but the ADA does not apply to housing. The ADA is not in effect when you're talking about housing. So this protection falls under what law that we're still focusing on with those 7 protected classes?
Fair housing.
The
Fair
Federal
Housing.
Fair Housing Act. We're still talking about the Federal Fair Housing Act. The ADA only governs places like shopping centers and malls and hospitals and hotels and restaurants, any places that are made for public access. But the Federal Fair Housing Act governs these residential settings. So we're talking about what a residential landlord would have to do to accommodate. And not just a landlord. How about a residential real estate broker who was showing someone who had a handicap or disability? Would a residential real estate broker who's showing a buyer and the buyer says, well, I have this disability, can you accommodate it? What's your answer?
Yes.
Yes. If their request is a reasonable one, then yes, you would accommodate that request based on their handicap or based on their disability. So let's talk about one of the hot button issues when it comes to reasonable accommodations. There's an awfully cute reasonable accommodation right there, folks. And yes, I chose that breed for a reason. Number one, I'm partial to them, but that's not why I chose them. I chose them because questions commonly come up. Well, what if it's this breed or what if it's that breed? And it does not matter, folks. A assistance animal is defined as a reasonable accommodation for someone with a handicap.
Yes.
So any person who presents with a handicap, who is again willing to provide written documentation that they have a disability and documentation that the animal provides them with assistance. First of all, do not take this further than it is. Could that documentation be a 1-paragraph letter from their doctor that says, Thomas has a disability for which his dog Zeus provides assistance, signed, blah, 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 blah. Could that be the whole documentation right there?
Yes.
Yes. It doesn't have to give any detail. Does Zeus have to have this vest?
No.
No. Does Zeus need a certificate from some online somewhere?
No.
No. Any documentation that this person is willing to provide in writing from some sort of a caregiver that says they have a disability and the animal provides assistance with that disability, that turns that animal into an assistance animal. Does that make sense for everybody so far?
Yes.
So let's talk about what that means for you all. If it is an assistance animal and you are in a residential setting. So houses would be residential, apartments would be residential, residential condominiums, residential, townhouses, residential. Here's my question for you. Patty is a new real estate licensee and her first buyer comes to the showings with a 12-foot boa constrictor draped around their neck and says that the boa constrictor is their assistance animal and must be with them at all times, and provides Patty with a letter stating such from their doctor. Does Patty have to allow the 12-foot boa constrictor on the showings?
Yes.
Yes.
Yes, and more importantly, does the listing agent who has those properties listed have to allow Patty to bring that buyer in there with the 12-foot boa constrictor?
Yes.
Yes.
Yes, they do. Yes, they do.
Yeah.
Jonas is a new real estate agent, and his buyer client shows up to the showings with a Saint Bernard who sheds and drools a lot. The buyer identifies the Saint Bernard as an assistance animal and has documentation that the Saint Bernard is an assistance animal. The seller, the owner of the property, is deathly allergic to animals. Does the animal have to be accommodated?
Yeah.
Yes.
Yes.
Yes. Yes.
That's how they'll try to throw you off.
And I realize that is going to put you sometimes in a very confrontational situation where you might have a seller that says, I don't want them in my house. They gave up that right, folks, when they hired who to sell their house for them?
Real estate agent.
Real estate.
A real estate
Because
agent.
we have to explain to them that we are not going to discriminate, and this is part of not discriminating. Does that make sense for everybody? Okay.
I could use myself as an example. So I have autism, and Blue Adeline is a service animal. She can sense when I'm about to have a moment or when it's kicking in, and will come up and will tell me and let me know that I need to step away. And that allows me to be able to do that. So it is very vital that, like with my job and with other things, that she be able to travel and be able to be with me.
Mhm.
And that's never been an issue because I have a letter from my psychiatrist that states that she serves as a service animal. This is what she is providing. And yes, this is legally binding or whatnot.
There you go.
Yeah.
Thank you for pointing that out. I mean, I love it when people share that. And listen, folks, I am such a fan of accommodating assistance animals and service animals because I do think it's so important for so many people. But it's important for us to know where the distinctions are, because obviously there are, unfortunately, some people who will try to take advantage, and some people who will try to claim animals that are not assistance animals, but that are, and that's part of the deal, is us trying. That's why we're allowed to ask for some form of documentation from a doctor, caregiver, psychiatrist, psychologist, somebody like that. I do want to point out while we're on this slide, before I jump one forward, this is the commercial version of an accommodation when it comes to an animal. Because in a commercial setting, we are not dealing with the Fair Housing Act. We are dealing with the ADA in a commercial setting. Over here, we are dealing with fair housing. The Fair Housing Act simply says an assistance animal. The ADA says a service dog. So let me ask you a question. Patty is a residential broker, and her buyer shows up with a 12-foot boa constrictor. Does Patty have to take the boa constrictor if it's an assistance animal on the showings?
You said residential, right?
Yeah,
Yes.
she's a residential buyer. She's showing houses. Does she have to accommodate the boa constrictor on the showings if it's an assistance animal?
Yes.
Yes. Same person, same exact person. You with me?
Mhm.
Patty and this buyer stop for lunch while they're out on the showings. The buyer is refused entry to the restaurant with the 12-foot boa constrictor. Is the restaurant in violation?
No.
No, because the restaurant is under the Americans with Disabilities Act, and the Americans with Disabilities Act says the only animal that can be a service animal is a what?
A dog.
A dog.
Service dog, yeah.
Everybody see the different treatment there, right?
Yes.
Okay.
Yes, but I have seen in public in Chapel Hill at University Mall when Southern Season was still, I worked there years ago,
Yep.
a miniature horse as
Yes. I often talk about the miniature horse in Chapel Hill.
we're just walking around.
Yep.
Wherever
Well,
in the mall.
First of all, miniature horses used to be covered and they've eliminated them from the list.
Okay.
That particular miniature horse in Chapel Hill, he's been around for a long time. He's one of my favorite stories. I always tell people, first of all, if you are driving through Chapel Hill and you see a Chapel Hill Transit van pass you with a horse sitting in the front seat, you are not smoking something. That's what you really just saw, because he does ride in the front seat of the van. His owner is blind. She is vision impaired, and he is a guide animal for her. And she's had him for a long time. He's awesome.
And she drives?
No, she doesn't.
Oh.
But Chapel Hill Transit is free. They pick her up and they take her where she needs to go, and she rides in the back of the van. The horse gets van sick, so he rides in the front seat. He sits in the front seat because if he gets in the back, he gets sick. So he sits. So we literally, when you see him going down the road, you see somebody driving a van, and they look like they're chauffeuring a horse because the horse is just sitting in the front seat over there. I mean, he sits right in the seat.
I love.
But the best thing about him was, the restaurant is not open anymore, but Michael Jordan used to own a restaurant in Chapel Hill, a steakhouse. And she used to come to the restaurant every once in a while. And Michael was fascinated by the miniature horse as a service animal. And he became even more fascinated when he realized that the horse has to wear shoes, rubber-soled shoes, so that the horse does not slide around. He has to have shoes on. And so Michael, still to this day, as far as I know, sends her several sets of Jordans every year so that the horse always wears Jordans.
I love it.
That is so cute.
I love it.
Always. So you always will see. And she has a very good sense of humor about it, because you'll ask her, because sometimes you'll see the horse and he has 4 matching Jordans on, and sometimes he has 2 and 2, and sometimes they don't match at all. And if you ask her, you're like, well, why are his shoes not matched today? She said, well, I picked them today, which is that's her
Oh
own
my
little joke.
goodness. But I'm pumped.
Like when he picks them, he picks the matching ones. When I pick them, they don't necessarily match.
That is funny.
That's a great story.
But yes, but now to your point though, Summer, this is minimally what those facilities have to accommodate. They can certainly choose to be more forgiving, and a lot of places are. We see a lot of places now that will accommodate in public settings service animals other than dogs, cats, or I've seen ferrets, and I've seen you name it. And we even had one at the school one time. Somebody came with a service tortoise.
We had an iguana at the first day of school.
And you had an iguana, so there you go. And the lady came in and she said, I have an odd request. She said, I have a service animal. And I said, well, that's not an odd request. And she said, well, you haven't heard what it is yet. And I said, well, what is it? And she said, it's a tortoise. And I said, as in a turtle? And she said, yes. And I said, oh, okay. So I thought, it's like, a little box turtle. I'm thinking, well, what does he do? He's on a leash. He came in on a leash. I mean, he must have weighed 40 pounds. He came on a leash, and she picked him up and she put him in the chair, and he sat right in the chair the whole day beside her. And he would come up and you'd see his head up over the top of the table. He was awesome. I loved it. I thought he was great. Now we did.
What service did he perform?
Well, I can't ask. I don't know. I have no idea. I don't know what he did.
Decided or any type. I mean, now it's like
He
that.
entertained me. That was a service. But I will say we did like Clorox down everything around it, because reptiles are weird. Like the reptiles have stuff. So we did after he left. We did. But his name was Squirtle. How cute is that? Squirtle the turtle.
I love that.
So you can allow more accommodations, but you have to allow these minimally. Now, questions that are going to come up on the test about these service animals or assistance animals. They are not pets. So anything that pertains to a pet does not apply to an assistance animal. Can you charge a pet fee? Yes, but not for a what?
Service animal.
A service or assistance animal, because it's not a pet. right? Can you have a no pet policy? Sure, but it doesn't apply to a what?
Assistance
Animals.
animals.
An assistance animal, because that's not a pet. Does that make sense for everybody?
Yes.
So basically, assistance animals are exempt from all of those regulations. Your HOA says you can't have pit bulls. That doesn't apply if it's an assistance animal. Your insurance says I'm not covered because it's a Siberian Husky. That does not apply if it's an assistance animal. This is federal law that these assistance animals be accommodated. Are we all good with that?
Yes.
And it basically supersedes any other law or policy. Now, that does not mean, let me point this out. I've had people say, so that means they can tear, I can't charge a pet fee for them. So that if they tear up the property, I'm just stuck fixing it. No, you charge the owner for the damage, just like you would charge them for any other damage. The only difference here is you don't treat the animal like a pet, you treat it like a person. Right? So you don't charge a pet fee because they don't have a pet. Okay. And Chassie was on a flight with a pig as a service animal. I'm sure
Can
that
you
was
charge
cool.
an extra deposit fee?
No, no, not related to the animal specifically. So you can only charge whatever normal fees, deposits you would charge if the tenant did not have the assistance animal at all. Okay.
So
Now,
if we're
sorry, go ahead, Grant.
I'm sorry. So I was just going to ask, kind of talking about the pets and, so if we're showing a property and, it's our standard, we're not, pets aren't allowed, when we're showing the house. And someone comes up with just a pet, not a service animal, and the homeowner is there or whatever, and says, oh, no, it's fine. They can take them in. Is it then okay for us to do that? Or would that be discrimination because
No, that's okay. I mean, that's okay because pets, I mean, if they want to say, oh yeah, you bring your pet in, that's fine. That's fine.
Okay.
If I understood your question correctly, you're basically saying, even though there's a no pet policy, could the owner all of a sudden just waive it because they say it's
right?
Okay? Yeah, that would be fine. That'd be fine.
Okay.
And Travis, confirm this for me, or just to make sure I'm correct. Now, let's say that you were doing a rental verification on a person moving into a property or a rental house. And on there it says, was there any damage? What did that consist of? You could charge a higher deposit based upon their rental history, correct?
Yes, that is correct. So if they have a history, so somebody brought this up to me one time and said, well, they had somebody with an assistance animal and the assistance animal was a Mastiff. And at when they talked to the previous landlord said, well, we had to charge them $3,000 when they moved out because the Mastiff's so heavy, his nails destroyed the hardwood floor. Right. And so, we had to have the hardwood floors refinished. And so, yes, you could charge them a higher deposit based on their previous history of creating damage at properties, as long as you did that consistently with all tenants. That if you had found other tenants that had the same problem, you were also doing the same thing with them. So again, you're not specializing the treatment based on the fact that they have an assistance animal. You're saying you as a tenant cause damage. We don't know if it's you or the animal, but as a tenant, you cause damage, and so we're charging based on that.
That's what we did. So
yeah,
okay, good.
And you can do that. Yeah.
Yeah.
Taj, I would say so. Yes. Taj asked, as brokers, do we need to tell the owners of the homes that we're showing there'll be a service animal at a showing? I would say yes, because they need to have the opportunity to protect themselves or at least speak up and say, well, I'm allergic. And that way we could try to help make arrangements to maybe have it cleaned after the showing or something to try, because we don't want to abuse one person to help the other. We want to try to be as accommodating to everybody as we possibly can. But
well, what if it's Seth and they have cats?
Well, right, exactly. I mean, because cats, people do have allergies to more commonly, and so it becomes an issue.
No, I mean, if you're going to bring a service dog in and they have cats, if it's only an assistant dog. Service dogs are better trained.
What a great point, right? If they're bringing in another animal and you already have animals in the house, they may need to know so that they can remove their own animals, because we're not hopefully not worried about how the assistance animal will react, but how would your animals react? I mean, I know for a fact, if you came into my house with an assistance dog, my dogs would go crazy. I mean, not in a bad way. They would be like, the dog would cease to be an assistance dog because my dogs would like tackle it and want to play with it and everything else in the world. And so I would need to know about that in advance to remove my dog. So that's a really great point as well. Yeah. Okay.
Travis,
Yes.
and what is going on now with everybody has I see advertising about like a no service dog, but like that you can buy a certificate and show
Yeah. So HUD has
crazy, right?
Yeah, HUD has finally come out and said all that's bogus. We don't we pay any attention to the stuff that comes from those websites, good, bad, or indifferent. We request documentation from a care provider, and that's all we're allowed to ask for. Okay. Now, to wrap up Elizabeth's question, because now we talked about those are all accommodations. Those don't cost us anything to make those changes. Now let's talk about the changes that cost real money. What if a residential tenant needs something changed physically about the property? Because that is going to happen as well. There is going to come a time when we have residential tenants who need actual physical changes to the property. They want and or need things like a ramp. Or the gentleman in the upper picture up there. I mean, if you'll notice, the lower cabinets have been removed in a couple of different places in that kitchen to allow for access for his chair. Those are examples of physical changes to the property that are necessitated by and this would almost always be a tenant, because buyers can obviously make changes to their property once they buy it. But these would almost always be tenant related, landlord tenant related. So what do we do as real estate brokers if a tenant needs a modification to the property? The answer is we say yes. We must allow for the tenant to do it. But look at this note down here, because this may show up on a test and you need to know it for the real world as well. We are required to allow the modification, but who can we as landlords require, landlords and property managers require pay for the modification, since there's an actual real cost associated here?
The tenant.
We can require the tenant fund the cost of the modification. And not only that, we can most times require the tenant pay to put the property back in its original condition as well. So the key here is residential landlords are not going to have to spend a bunch of money, but they are going to have to get out of the way and allow people to spend their own money if they need these modifications. Does that make sense for everybody?
Is it in the lease?
It does not have to be in the lease, but because this is the law and because this could happen at any time, you could have somebody who didn't need the modification when they first leased the property, and then the need arises while they're in the property.
But what about the agreement to put the property back? Doesn't that need to be in writing?
Oh, I would say when they make the modification, you would want to put that in writing. So you might want to add that to your lease agreement or have some separate statement where they've committed to it, paying to put it back as well. So are we all good on the modification? Okay. So again, accommodations don't cost anything. Modifications cost. Accommodations, change in the way we do things. Modifications, changes to the property itself. Everybody good on the differences there? Feel pretty good about those?
Yep.
Yeah, make sure you're good with that terminology. So why don't we do this? That is probably a good break point for lunch break, because we definitely have more here than we can finish reasonably before lunch in this in the fair housing chapter here. So why don't we pause right there for our lunch break?
A good plan.
So before we stop for lunch, we were talking about these discrimination laws, and specifically about the Federal Fair Housing Act. And we spend a lot of time on the Federal Fair Housing Act. So remind me again, how many groups or protected classes are there during the Federal Fair Housing Act?
7.
7.
Anybody want to take a stab at what they are?
Fresh corn.
Fresh corn.
Fresh corn, yep. And so you take the E and O and make equal opportunity out of it, and then you've got the other 7 letters there to help you spell it out. So the F is for familial status, the R for religion or race, either one. You can do religion or race with the first R because you got 2 R's in there. And then the S, what's the S?
Sex.
How about the H?
Handicap status.
Handicap, good. How about the C?
Color.
Color, right?
Color.
And then the second R is either going to be race or religion.
Race or religion.
And then the N is what?
National.
Origin, nationality. So like country of origin, for as an example. So if you were to use, an example from like, current events, if a real estate broker were to say they didn't want to lease a residential apartment rental to somebody because they were a refugee from Afghanistan, would that be protected under the Federal Fair Housing Act? Is that something that's protected?
Yes.
Yes, that's what that national origin means. It means literally, where are you from? What country of origin are you from? And so that's another one of those things that are protected as a group. You need to know this vocabulary word. The vocabulary word that they will test you on as it relates to fair housing violations most likely is something called steering. Now, that's not the only vocabulary word we have to deal with as far as fair housing violations, but it is by far the most common vocabulary word that you'll see for fair housing violations. Steering is essentially pushing buyers or tenants, somebody who's buying residential property, because remember, it's only residential property with fair housing. So you're pushing somebody that is buying residential property either toward or away from. And Seth, to me, always kind of sums this up the best possible way when he says he thinks of it as he drives buyers around. So he steers buyers, right? You steer buyers. In other words, if you are committing a violation that is with a seller, it's not going to be called steering. If you're committing a violation that's with a landlord, it's not going to be called steering. If you're committing the violation on the buyer side, on the tenant side, that is called steering. So basically, there are lots of different examples of steering, but sometimes people get confused about, okay, how do I give advice without steering? Well, we can give advice about anything that's not on that list of 7 things. So if someone says, is this a good area for resale value? That's an entirely appropriate question for us. If somebody says, is this a good area for kids? That's not an appropriate question for us. Not because we might not know, not because it might not be more or less important to that buyer or that tenant, but strictly because one is on the list of no-nos and the other one's not. And so the difference between steering and advice is, are we talking about something that's on that list? If we're talking about something that's on that list, then answering those questions would be steering. If we're talking about something that's not on that list, then answering those kinds of questions would simply be advice. Does everybody see the difference between that?
Mm-hmm.
Okay. And that's, again, on the buyer's side of things. If you're on the seller side of things, the other vocabulary word for a fair housing violation is something called blockbusting. Blockbusting is basically scaring people who own property into selling because of one of those 7 protected classes. Well, you should probably sell your house now because you see those people that just moved in across the street. You know what happens to property values when they come to town. That's blockbusting. Blockbusting is using one of those 7 protected classes as sort of a way to terrify people into selling. So like right now, we have a very huge lack of supply in the housing market. If you were to go around knocking on doors in a neighborhood and saying, there's a lot of weird things going on at night in this neighborhood. I'm not sure it's the safest neighborhood in the world for your kids. Might not be a bad time to think about selling. in addition to that being sort of a crappy thing to do, what would that also be called? Since you talked about children as a reason they should be selling, what's the name of what you just did?
Blockbusting,
That is blockbusting.
which something also rings a bell for me for panic peddling.
Yeah, panic peddling. Blockbusting is also called panic peddling, like you're selling fear, right? Panic peddling means selling fear. So that is blockbusting as well. Okay. Are we all good on that vocabulary so far?
Mhm.
Now, advertisements are probably one of the places where we have to be most careful in not violating fair housing, especially on the exam. They are very likely to give you examples of advertisements that you need to pick what's not allowed. And so don't advertise in, magazines, newspapers, circulars, social media groups that focus on one ethnicity, one nationality, one language only. Make sure your marketing is reaching the broadest possible group of people. Try to stay away from any descriptions that stick to people. Don't say something about, the people that are going to occupy the property. Talk about the property itself. Don't use, and people like to do this as like geographic reference points. Don't use houses of worship as geographic reference points when you're describing a property. Across the street from St. James United Methodist Church, just down the street from the new cathedral in Raleigh, 2 houses down from the such and such temple. Don't do that, because again, what people could read between the lines there is when you're saying right across the street from St. James United Methodist Church, are some people going to see that as, well, I'm not Methodist, so I guess I shouldn't buy that house? Are some people going to read that into that description?
Yeah.
Yeah. And that's what we have to be concerned about, right? So stay away from that. This one, so I'm just going to be real honest with y'all here now. Y'all, I'm going to be more honest than I should be. Okay. Number one, by rule, you are not allowed to tell me what you see on the license exam. When you go take the state license exam, you're not allowed to tell me what's on there by rule. You could lose you could lose the license you just got. I could lose my license. So please don't do that. Don't come back and say, oh, I had this exact question on the state exam. Don't do that. Everybody clear on that?
Mm-hmm.
Don't do it. That does not mean I am deaf, dumb, and stupid when it comes to people asking me questions after they've taken the license exam. And so I'm just going to spill the tea the best way I know how to do it here with you. I've had like 30 students over the last 3 or 4 months ask me what this word means, antebellum. And coincidentally, first of all, does that seem like an odd word that people just randomly sort of say, what does this word mean?
Yes.
Yeah, it's not a very commonly used word, right? And coincidentally, all 30 of them had just walked out of taking the license exam. Now, I'm not saying that they ask you about this word on the license exam. I'm just saying there seems to be this coincidental type occurrence where people who have recently taken the license exam want to know why about the word antebellum and why it might be something they need to be aware of. Y'all, Seth said he was picking up what I was putting down. How about y'all? Y'all picking up what I'm putting down here?
Yeah, I got it.
Yes.
We got the number.
Don't use that word. And I'll tell you why you should not use that word. Many people are not familiar with the context of that word. Antebellum literally translates to before the war. It is, that is the literal translation of that phrase. It's a word that comes from Latin phrase that means before the war. However, it has been used to describe properties before one certain war, the Civil War. And so the word has been used in this context before in the past. You know, come enjoy an antebellum lifestyle. Well, folks, who the hell would want to? I mean, no. Just no. Nobody wants an antebellum lifestyle, because we're talking about a time when millions of people were enslaved, right? So don't use that word. And if you, I can't with the comment there. But if you see it on a test, that word should not be used. Now, I will point this out. If it's used as an adjective, like antebellum style, that's less severe than saying it's an antebellum property, because you can say like an antebellum style, which could be a newer home that's built and to be styled like older homes. I still wouldn't use it, but definitely just don't use like antebellum home. Are we all clear on that?
Yeah. For those of you who like country music, if you know, there's a country group called Lady Antebellum. They changed their name. They're Lady A now because of that word.
Oh, are they? Okay, so I knew I had heard of Lady Antebellum, but I did not realize they had changed their name because of that.
Yeah.
So there you go. So here's what that tells me. Somebody who writes these test questions for PSI is a country music fan, and they got that stuck in their craw about it, because why else would that word all of a sudden pop up in everybody's radar, you know? So, right. I mean, you got to remember, people writing these tests are human. So like, you know, somebody's like, oh, I know how we can get them on real estate tests with that, you know. But there is one time where advertising is allowed to be discriminatory. I think this is a very ripe piece of fruit for a test question right here. Okay. I think there's a very, very high likelihood that you're going to see a test question about this, because it's the only time that advertising in residential real estate can be discriminatory. Even in instances where discrimination is allowed, you can't advertise that you intend to discriminate against those protected classes, except one time. There is one time where you're allowed to advertise actively and tell the world, we're not renting this to everybody. There's one group of people that we are restricting occupancy to. How many of you have ever seen this? Female seeking female roommate.
Yes.
Mm-hmm.
The reason that's not a violation of the Fair Housing Act is because it's specifically an exception. It's specific, and there's actually kind of an interestingly cool story about how it became an exemption, how it became an exception. It was not at one point in time, and an 80-some-year-old lady in Ohio was fined for violating the Fair Housing Act for placing an ad in the paper that said she was seeking a female roommate. And she took that case. She sued the state Fair Housing Board and ended up all the way in front of the United States Supreme Court. And they said, okay, this is not a violation. She can advertise that she's seeking a female roommate. And because it's not just women seeking female roommates, any person can advertise for a roommate. Now they cannot, here's what you can't do. Do not take it further than it goes. I did not say you could advertise and say house for rent will only rent to females. You can't, this is only if you're going to be living with the person that you're renting to, that you're literally looking for your what?
Your roommate.
Your roommate. You are it's called the roommate rule, right? You are looking for your roommate. You are going to be living in the property and you are searching for a roommate. You can advertise that you're looking for a specific gender and not be in violation of the Fair Housing Act. Everybody okay with that statement? We good there?
Yeah.
Mm-hmm.
Okay, good. There are some other exemptions to the Fair Housing Act that I think you may see test questions about. They're very specific, and I'm going to try to make them as clear as we possibly can. But in general, if it's a residential property, it's subject to the Fair Housing Act. in general. We're going to talk about the narrow exceptions here, but just remember, rule of thumb, if it's a residential property, it's governed by the Fair Housing Act. But we do have one major exemption, and it's one that we actually already had a question about. I think it was Rachel earlier who brought up the 55 and up communities. Was it you, Rachel? Yeah. Yeah. So the 55 and up communities. Now, I've had people say, well, this is not an exemption because age is not on the list anyway. It's actually not age they need an exemption for here, folks. Can you think of any group of people that is protected by the Fair Housing Act that you would be discriminating against if you say only people 55 and up can live here?
Children.
Children. Normally, you could not restrict a neighborhood and not allow children. But a 55 and up community can do exactly that. And the reason they can do exactly that is because they are specifically exempted from that one protected class. Now, I don't want you to think that 55 and up communities are exempt from the Federal Fair Housing Act. They're not. They just have 6 protected classes instead of what?
7.
Instead of 7. Right? So basically, if you look at a 55 and up community, you still cannot discriminate on the basis of race. You still cannot discriminate on the basis of color or religion or national origin or sex or handicap. But you could discriminate on the basis of children. And as a matter of fact, not only can you discriminate on the basis of children in these communities, you can have all kinds of rules that say no children allowed, no children can use the facilities, no children can stay as guests on the property. Could you have covenants in a neighborhood like this that said you can't even have a child as a guest in your home?
No.
No. Well, if it's over 55.
Yes,
yeah.
but you can.
Yes.
Could you have covenants if they're exempt
That
from
exist. Mhm.
children being protected? Could we have covenants
Yes.
that literally say you cannot have a child be a guest in your home in that neighborhood?
Yes.
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 But we can ignore them.
Good. No, you don't ignore them because there's nothing wrong with that in this neighborhood. That's exactly what this neighborhood is about. This neighborhood exists to do one thing. And what is that?
Keep children out.
To discriminate against children.
Mhm.
That is the only reason these neighborhoods exist at all, because they hate children. These are people who hate children, and they hate children so much that they went to the United States Congress and got a special law passed so that they could have neighborhoods that say no children allowed. I mean, I don't know how to come to any conclusion other than they don't like kids a lot.
Now, as far as the roommate rule, are they as well they only have 6 and one that they're allowed to discriminate against?
So with the roommate rule, they can advertise. The roommate rule has specifically to do with advertising. So I understand what you're asking, and yes, you're somewhat right, but the roommate rule is more about the ad that you place. Normally, you cannot place any sort of discriminatory advertising, even if your discrimination is going to be allowed. But the roommate rule is the one exception to that, where you can actually advertise, just outright say, we're not going to allow these people. Okay.
But it's just for that one class, just for.
Correct. Just for the gender of your roommate.
Just for gender.
Exactly right.
Okay.
Exactly right.
So not to go on a huge tangent, but like, correct me if I'm wrong, the 55 and up community couldn't say on a sign, we don't accept children?
They cannot.
Okay.
Cannot. They can clearly identify themselves as a 55 and up community because that is the language that is allowed by the exemption. And then they can have covenants that address the children, but they can't put an ad in the newspaper that says, come live child free. because you're not allowed to advertise that you're discriminating. Does everybody see the difference?
Yes.
Right? Even though they're discriminating, they're not allowed to advertise that they're discriminating. So that's why the roommate rule one is important, because it's the one time where you can actually take out an ad. You could put put an ad right there in the newspaper. You can put an ad on Facebook that says, seeking a male roommate. That's the one time you're allowed to advertise it. Okay, exactly. There goes the marketing campaign. So these 55 and up communities do have rules. You cannot just magically all of a sudden declare yourself a 55 and up community. You have to meet certain qualification guidelines to basically be able to discriminate against children. First one, and this is the hardest one. This is why you almost never see a neighborhood changed into a 55 and up community. You see most 55 and up communities start as 55 and up communities. Because look at the first qualification. At the time you declare the neighborhood as 55 and up, there have to be how many children living in the neighborhood at that moment?
Zero.
Zero. It is very hard to imagine if you had already started to sell properties in there that you would still have 0 children living in the neighborhood. Does that make sense for everybody? We actually joke about this with my parents, or have joked about it. And now it doesn't work anymore because they had one family buying the neighborhood who has kids. But my parents live in a neighborhood up on Lake Gaston, and there's something like 72 houses in there. And at one point, about 3 years ago, there was not a single child living in those 72 houses. Now, about half of them are just summer homes. So only about half of them are occupied year round. But of the 30-some that are occupied year round, there was not one child living in any of them. And so I joked with mom, because she's also an agent. I was like, well, you could actually become a 55 and up community if y'all wanted to, because, you all are already pretty much 55 and up, but you meet this criteria, which is weird because normally you would never see this. But one house was sold to somebody with children. And so now could they become a 55 and up community right now if they wanted to? No. So this almost always happens from the very beginning, the first development. Is everybody all right with that? Okay. The second rule, so that's to get the initial sort of stamp of approval as a 55 and up community. This one is going to be ongoing. So this one's kind of up front. Up front, you got to have 0 kids living there. Ongoing, and this has to be checked continuously. Of the adults living in the community, which is going to be everybody else, at least 80% of them must be over the age of 55. How do I think they might try to come at you on a test with that? Could they say everybody has to be age 55? Could they put that up on the test?
Yep.
That everybody has to be age 55 and up. And would that be true?
No, not true.
No. Can somebody 21 years old live in one of these communities?
Yep.
Yes.
Yes. It's not only for people 55 and up. It says that at least 80% of the people there have to be 55 and up at any given time. Now, y'all know who's in Congress, right? Bunch of old men, right?
Mm-hmm.
I cannot imagine why a bunch of old men writing a rule would write in an exception where they could have a trophy spouse. I cannot imagine how this 20% got in there. I mean, they had to account for the 70-year-old old geezer with a 30-year-old wife.
I'm sure.
And that's why it's not 100% 55 and up, But it is weird. I will tell you this. When you help somebody who buys in one of these communities, it is a little bit odd if they're not both over 55. And I've had that one time before, and it wasn't a big age spread. I think the wife was 58 and the husband was 53. So they were both right around, but she was over and he was not. And so they wanted to buy a house in there. I said, well, I'm going to have to check with the HOA. She said, well, what do you mean you have to check with the HOA? I said, they may already have too many young people here. You can't buy in here unless they've got some room. Does that make sense? 55 and up can buy in there, but anybody under 55, you got to check to make sure they don't have too many of them already. Does that make sense for everybody?
Yeah.
Yes.
So I had to
Wondering about
literally
that.
go, I had to go to the HOA and I had to say, okay, how many people under the age of 55 do you have as owners in the neighborhood? Because I got a buyer and one's over 55 and one's under 55. And I had to make sure that we were still within that workable percentage for the neighborhood. Because here's what happens. If you get more than 20% of the adults who are under the age of 55, the exemption goes away. And then all of a sudden, who can live in the neighborhood?
Children.
Children. That exemption goes away. Taj says, what happens if a 30-year-old bought in the neighborhood and ends up having a baby within the next few years? Does she have to sell her house to keep the exemption? Well, she doesn't have to sell it, but she can't live there. She can rent it out. They cannot stay there. That child cannot be there. And I'm telling you folks, they're serious about this. Even to the extent of it being nasty sometimes. And this has probably been 2 years ago now, maybe 3 years ago. There was a couple in Ohio who lived in one of these communities, and their daughter was killed in a car accident. Daughter and daughter's husband were both killed in a car accident, leaving their 14-year-old son with no surviving parents. Grandparents became guardians of the 14-year-old son, and they lived in one of these 55 and up communities. And the HOA immediately said, if you don't sell, we're going to foreclose on your house. You got 30 days, either sell or we will foreclose on you because he can't live here. So, I mean, they're not playing with this exemption. They mean it. They mean it. Okay. Are we all okay on the 55 and up communities?
Yeah.
Okay, good. Good. There are some other much more narrow exemptions to the Fair Housing Act, none of which involve us, so we're not going to spend much time talking about them, because anytime a real estate broker is involved in the transaction, there are no exemptions to the Fair Housing Act. Real estate brokers, except like the 55 and up communities, but real estate brokers pretty much mean that the Fair Housing Act has to be followed. But there are some situations where people decide not to be represented, where they might have the right to be exempt from the Fair Housing Act. The first one is a FSBO, a for sale by owner, is exempt from following the Fair Housing Act. Now, let's be clear about what exempt means, because I think sometimes I say that and you hear it, but it doesn't really process. If I say a FSBO is exempt from the Fair Housing Act, can the for sale by owner refuse to sell to someone because they are Chinese?
Yes.
Yes.
Yeah.
Yes.
That's deception. It has deception.
Even though that would be discrimination, even though that would be based on national origin, even though that would normally be protected by the Fair Housing Act, a FSBO is what?
Exempt.
They're
Exempt.
exempt. They do not have to follow this law. Does that make sense for everybody?
Yes.
Okay. Now, look at these bullet points though, because these are important. They can't hire a real estate firm, which they wouldn't be a FSBO if they hired a real estate firm. And then this big one right here, what can they not do? They can discriminate, but they can't what?
Advertise it.
They can't advertise it. So 2 questions, and I want to make sure you understand it's 2 different answers. Can a FSBO refuse to sell to somebody because they're Chinese?
Yes.
Yes.
Can a FSBO put a sign in the front yard that says no Chinese buyers allowed?
No.
No.
Because that would be advertising the discrimination. Does that make sense for everybody?
That is clear.
Okay, 2 different situations. Okay, and then the last one that would cause them to not be exempt is if they own more than 3 residential properties at any one time. Basically, if you own more than 3 properties, the law says you're basically, full-time professional real estate, even if you are a FSBO at this point, so you should know the law and you should follow it. So somebody who's an investor that owns like 15 rental homes, even if they sell one of those FSBO, they're not exempt because they own too many of them. Everybody okay on that?
Yeah.
This is basically meant to exempt somebody selling their own house. And I'll tell you why. And I've had people say, well, why are they even exempt? And I'm not defending it. I'm just telling you why the exemption's there. There are quite a few people that when they sell their own house are selling it, especially people who are not selling it through the services of a real estate broker. They want to be able to sell it specifically to like a family member. They want to be able to specifically sell it to somebody who goes to their church. They want to be able to specifically sell it to somebody who is part of their same little club at wherever. And so the law basically recognizes that. It says, okay, as long as you're not putting it on the market to the rest of the world, as long as you're not hiring a real estate broker, as long as you're not advertising and telling everybody that you're discriminating, and as long as you don't own more than 3 residential properties at once, you can sell to whoever you want to, and we don't care. That's essentially what this exemption is. Does that make sense for everybody?
Yeah.
Okay. So that's one exemption, which is going to be pretty narrow because let's be honest, there's not that many FSBOs out there anyway. Last I checked, about 90% of people list their property with a real estate broker. So FSBOs are a very small part of the marketplace anyway. Landlords could also be exempt. Now recognize a FSBO is doing what with their property?
Selling.
They're selling it. A landlord is doing what with their property?
Renting.
Renting it out.
Renting it. This one is much less broad than the FSBO. Please do not read this and say all landlords are exempt from the Fair Housing Act. That is not what this says at all. I want to be clear. If you're a residential landlord and you're renting out the entirety of a property to somebody, you have to follow the law. So if you're renting out a house, do you have to follow the law?
Yes.
Yes. If you're renting out an apartment you own, do you have to follow the law?
Yes.
Yes.
Yes. If you're renting out a townhouse you own, do you have to follow the law?
Yes.
Yes. The only time landlords are exempt is when they're renting out a room to a roommate, when they are going to live with the person that they are renting to. So instead of renting out the whole house, they're renting out their basement. Instead of renting out the whole duplex, they're renting out one side of it while they live in the other side. Does everybody see the difference?
Mm-hmm.
Yes.
Yes.
Okay. So in the event that you, as the owner of the property and the landlord, or a member of your immediate family, so like spouse, children, are going to live in the property, then you can discriminate in who you rent to. Essentially, you can choose your roommate. Everybody okay with that?
Mm-hmm.
As long as you don't hire a real estate firm, as long as you don't advertise the discrimination except one type. What's the one type of advertising that would be okay in this case?
The gender.
Looking for a female.
The gender one. If you're looking for a specific gendered roommate, is everybody okay with that?
Mm-hmm.
Okay. Or you cannot be renting out a room in a property that has 4 or more total units. In other words, in an apartment building, even if you live in the apartment building, but it has 10 units, can you discriminate who you rent to?
No.
No. If you own an apartment building with 3 units and you live in one of them and rent out the other 2, can you discriminate in who you rent to?
Yes.
Yes. If you own a duplex that you live in one half of it and you rent out the other half, can you discriminate in who you rent to?
Yes.
Yes.
If you own a townhouse in Chapel Hill and your daughter lives in it while she goes to school, can you discriminate who you rent to?
Yes.
Yeah.
A room with her. They're going to share it with her.
Yes.
Yes.
Yes. Yes. As long as you don't hire a real estate firm, advertise your discrimination, or as long as the property doesn't have 4 or more units. Everybody okay with that?
But you can only discriminate on gender.
No, you can discriminate on anything. You can only advertise that you're discriminating on gender. You keep missing that. That's the one that's for advertising purposes. You can discriminate. Let's say that, for example, that William owns a townhouse in downtown Raleigh where his son lives while the son goes to NC State. And so William has decided that he's going to rent out one room in the townhouse. Everybody with me so far?
Yeah.
So William owns the property, his son lives in the property, and they're going to rent out one room. Can they refuse to rent that room to somebody because of their religion?
Yes.
Yes.
Can they
Yes.
refuse to rent that room to somebody because somebody has children?
Yes.
Yes.
Yes. Can they put in the ad, no children allowed?
No.
No.
No, because that would be advertising the discrimination. Is everybody with me so far?
Yeah.
Yes.
Yes.
Can they choose to only rent that room to male tenants?
Yes.
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 Can they put in an ad, only male tenants need apply?
Yes.
No.
Yes.
No.
Yes. That's the one exception to the advertising rule, folks.
Okay.
There's one time you can advertise that you're discriminating. It is when you're renting out a room to a roommate and you are discriminating on the basis of what one specific thing?
Sex.
Gender.
Gender.
Sex, yes or no?
Yeah, right. The yes or no question. Exactly. Is everybody getting that? Because I want to make sure you're not confused on it, right? So let's go through another one. Okay. Let's say Aaron owns a house with a finished basement. Finished basement's got its own exterior entrance, got its own kitchen, got its own bathroom. It's basically a completely separate apartment from the rest of the house. Everybody with me so far?
Yes.
Okay. She decides for extra revenue, she's going to rent the basement out. Okay. Now, she's not a real estate agent yet. Oh, there you go. She does have a basement. Here we go. Okay. So let's talk about what she can do with her basement. She decides to rent the basement out. Can she look at somebody's application and go, ooh, they got 3 kids. I don't think that'd be, they're going to tear my place up. Could she do that legally?
Yes.
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 Yes, because they're going to be living with her. Does everybody see that?
Yeah.
Mhm.
Yes.
And they can discriminate on color?
And
Yes.
she can discriminate on anything except race, because race never had any exception. That's the Civil Rights Act of 1866. Okay.
Okay.
So could she refuse to rent to somebody because they are Christian or because they are Buddhist?
Yes.
Yes.
Yes. Could she refuse to rent to somebody because they're handicapped? Could she say, you know what? No, I just
Yes.
Yes.
I'd be uncomfortable with you being down there. You in that wheelchair, it just kind of freaks me out. Could she say things like that?
Yeah.
That's horrible.
In the law.
Yes.
Yes.
Yes. She could. Could she put any of that in any sort of a public facing ad for the property?
No.
No. But here's the last one, because you need to see the difference. Could she run an ad that says only female applicants need apply?
Yes.
Yes.
Yes, because that's the one time her advertising can also be discriminatory. She could discriminate against against gender, but she couldn't advertise that without that exemption. Does that make sense for everybody?
Yes.
She can discriminate against religion, but she cannot advertise that she's discriminating against religion. She can discriminate against national origin, but she cannot advertise that she's going to do that. She can discriminate against gender, and she can advertise that she's going to discriminate against gender. Are we all good on that now?
Yes.
William, that help? I hope so.
Travis, can I ask a question?
Yes, it did.
Sure, go ahead, Rachel. Good, William.
Okay, so we have a rental property in the mountains, and how do you filter people that are applying without discriminating against, because you do want someone in your home that's not going to tear it apart and all this stuff. So how do you do that legally without breaking these rules?
I try not to know anything about them that would fall into those categories. I don't ask questions about them that would fall into those categories. So as an example, on my rental applications, I do not ask the ages of the occupants. I simply ask for total number of occupants. I do not want to see them. I prefer not to see them and meet them in person, quite honestly, if at all possible. Now, obviously, that's not all possible because sometimes you need to show them the property. But in a perfect world, I would have never seen them. That way I don't have, because the whole a picture's worth 1,000 words type thing goes a long way in discrimination things. I would prefer they just be an application on paper. That way I can evenly compare them with everybody else.
Do you require anyone over the age of 18 to be on the lease or to have an application processed or a background check done?
Well, it's been a long time since I've done residential property management, but when we were doing residential property management, we did require anybody who was going to be an adult applicant to also apply. However, we would let them do so after the main applicant had already been approved. That way we weren't aware of what the mix was when we were approving the main applicant, and then we would check the other ones after the fact.
Makes sense.
Yeah. That way it didn't influence our decision, because I get what you're saying. Basically, if you're saying, oh, well, we've got 4 total applicants, and then you say, okay, well, I need everybody over 18 to be on the application, and they put 2 names on the application. Well, that tells you, well, the other 2 are what?
Exactly.
I mean, it's just another way of asking the question, right? And so you have to be real careful. You have to be real careful about that, because you don't want them to feel like they're being shut out because they have children and somebody else who doesn't have children is being put ahead of them, so.
Right.
It's definitely a balancing act.
What about pets? Can you say anything about pets?
Sure. Pets are not protected.
Right.
Not a protected class. So we're only talking about those protected classes.
Okay.
All right. Everybody good on these? Feel pretty good about the exemptions? Good.
Travis?
Yes.
Regarding the FISBO, I thought there was a rule where say you can't own 3 properties at more than 3 properties at one time. Isn't that where it's within 2 years? So say like if you sold a property, you still have to wait 2 years after that selling point.
You're thinking about for capital gains taxation purposes. That's different than with the FISBO exception for fair housing. The FISBO exception for fair housing deals with the number of properties you own at any one time.
Okay, so separate. Okay, thank you.
You're welcome. Okay, so we talked about the roommate rule. This is just another reminder of that. I'm not going to go through that again, but that it's a good one. I really think it's a big target for a test question. I do give you a note here. If you're not already reading the textbook, obviously I recommend you do that. But do read the examples on pages 78 through 80. I think it's really helpful with fair housing to read as many examples as you can get to get an idea of what is allowed and what is not allowed. So just a kind of a reminder to go back and check those. In North Carolina, the Fair Housing Act is going to be enforced by the North Carolina Human Relations Commission. The HUD handles complaints at the federal level. Most of the time, they will send complaints back down to the state level so that the state Fair Housing Board can handle them. But in any case, complaints have to be filed within a year of the violation. In other words, if somebody feels they've been discriminated against, they have how long to file their complaint?
1 year.
1 year.
1 year. And by law, HUD and the Human Relations Commission have to respond to the complaint within 100 days. And I will tell you, you may see test questions, and we've mentioned this before about the Real Estate Commission and them being able to fine you as a real estate broker. Remember, they cannot fine you as a real estate broker. There's no fining, no monetary penalty from the Real Estate Commission. But a Fair Housing Board can absolutely fine you, and they absolutely will fine you if they find you guilty of a fair housing violation. So please be aware of that. Lenders are also prevented from discriminating when they are issuing loans. That process of discrimination lending is called redlining. So when you hear redlining, redlining has to do with lending practices. It basically, certain lenders used to just take a red Sharpie and draw a circle on a map and say,
Yep. We're not going in.
we're not going in here. We're not lending in here. We don't care how qualified the borrower is. We're just not going to go in this area because the kind of people that live over here, you don't want to loan money to. That was the practice, and it's called redlining, and it is very much illegal. So anytime we have a lender that's refusing to loan money because of some sort of discriminatory practice, it's referred to as redlining. So that's just a vocabulary word, you know. We did mention earlier the Americans with Disabilities Act. Remember, this is different than the Fair Housing Act. If you had to like sum up the difference, the Fair Housing Act applies to what kind of properties?
Residential.
The Americans with Disabilities Act applies to what kind of properties?
Public.
Public.
Right, those kinds of properties. Basically, the Americans with Disabilities Act states that publicly available facilities have to be publicly available, meaning all members of the public, regardless of disability, should have equal levels of access. And you see this law in action around you all the time. I think in some ways we've become so accustomed to it that you don't realize how much of an impact this law has. If you travel around the world, sometimes you will become acutely aware of how much of an impact this law has. And I will tell you, as someone whose father is disabled and has mobility issues and is usually in an electric scooter, he's an amputee, it makes a difference. I mean, it's amazing how frustrating it can be to get to a place where there are no cut-ins in the curb, and that you can literally be 10 feet from where you're going and you have this person who can't get there because there's no way for them to get off the curb. And it's terribly embarrassing for them. And so I'm thankful for these laws, even as somebody who works in real estate and recognizes that they can be a tremendous pain in the rear end for developers to try to deal with them. So there's definitely a trade-off there, but we do see this in effect around us at all times. An example would be swimming pools at hotels. What's one thing you can think of that you see at every hotel swimming pool now that you would have never seen 15 or 20 years ago?
One of those things that lowers people into the water.
Yeah, the chairlifts. That's exactly right.
You see them in residential neighborhoods too, but I think it's because it's a commercial area.
That's exactly right. As they're being developed, the ones that are being built now have to be in ADA compliance, which specifies you got to have the lift, and so as time goes on, you will see more and more properties that are in compliance with the Americans with Disabilities Act. Generally speaking, older properties don't necessarily have to retroactively come into compliance, but newer properties as they're built have to be built to be in compliance. So, you see that around you on an almost daily basis. And it does require the owner of the property to make it fully accessible. Now, if that means they're not going to change the property, they have to change the way they do business. As an example, my hometown makes one of my favorite ADA sort of accommodations for the post office. The United States Post Office in Tarboro, North Carolina, is this beautiful old granite building on Main Street, but there are 39 stairs from the street to the front door of the post office. And the post office was built in 1830. There is no elevator in that building. And there's no way to put a ramp on that building because we are talking steep stairs up to the front of that building. And so if you are a handicapped person who cannot do the stairs, they make an accommodation for you. They literally have you drive around back, and they have a buzzer that you press, and you tell them your name and you tell them what you need, and they bring it down to you. They send somebody out and they bring it down to you. And so that's a way of accommodating for people with the Americans with Disabilities Act versus having to change retroactively change the building because of it. So that gives you an idea of that thing. Everybody okay with that? And I think that is it. That covers everything. So what question do I have here? What if you have a rental that specializes in single mothers for missionary work, let's say for work, but I own it, but I don't live there. I just provide housing. I would say, generally speaking, Chassie, that would not be allowable to have a rental that specializes for single mothers because of familial status, the mother's part. The single part would not be a protected class, but the mother's part, the parent part would. Now, you did put in there missionary work. So if that property was owned by a religious organization, there is another exemption for religiously owned housing there. And that, so it might be exempt because it's religiously owned, but it would have to be owned by the religious organization, not owned by a person in that case. As far as I know, that would not fall under an exemption. What do vacation, somebody asked in the chat, do vacation rentals have to make accommodations? And yes, they do. The vacation rentals are considered residential properties, and so they do have to make accommodations where appropriate. Patty, you had a question?
Yes, when we were talking about the antebellum home, in the book, it says an antebellum home was built before the Civil War. HUD advertising guidelines do not prevent marketing this information. So I'm kind of confused.
So you can say that the home is of an antebellum style, but what you don't want to say is the home itself is an antebellum home. So, because that intonates all the history that goes with pre-Civil War, and so it's sort of a narrow sort of thing.
Okay, I thought I might get tripped up on the test on that one.
No, I want to make sure you don't too.
Thank you.
All right, that wraps up fair housing, folks, and that wraps up unit